May I please?
Yes.
My lord, I'm praying, my lord, there is a requirement of some correction to be made in an order, my lord. Can this matter may be taken up tomorrow?
You give to the court master.
Yes, lord. Obliged.
Pending matter for list.
It is spoken to.
Pending matter for listing, my lord.
Listing give to the court master.
Yes.
May I please, Lordship? Lordship, with the consent of the other side, Lordship, item number 25, Lordship, kindly pass over the matter for the day, Lordship.
Item
25, Lordship. 25.
the prayer made by Carolina Council for the petitioner. Matters to judge on today. We'll start with 2 weeks.
Lordship, I beg to mention item number 43 from supplementary list.
40,
43, Lordship.
3.
Kindly matter may be adjourned for the day, Lordship.
Password for the day and split for Carolina Council for the petitioner.
Daily list item 1 for motion.
There is a contempt proceeding, my
The
lord.
date of the order.
Lordship will find the order at page 13, my lord.
Tell me the date.
Lordship,
Tell us the date.
the order was passed on 23rd January 2024.
Okay. The Burma password for the petitioner. Contempt. Notice steps. Pendency should not be bad.
Oblige, your lordship.
Item 2.
May I please, your lordship?
Yes.
Lordship, in this matter, the petitioner is aggrieved by the discharge order issued in his favor. The crux of the matter is that on 7/10/2004, he was appointed as a rifleman GD in Assam Rifles. Thereafter, Lordship, on 21/4/2022,
You filed an appeal? No.
Lordship,
Have you filed an appeal? No.
no, I haven't filed any appeal.
Against the order of discharge, appeal would be maintainable. Is it not?
As per my instruction, he has resigned, Lordship. With the instruction received, Lordship, it may be taken up at 2, Lordship. I'll
Okay, act to it.
go through it.
Item 3.
But even if, even if they are resigning because of medical condition,
Lordship.
you must undertake a exercise to see whether they will, how many years of service you had put in?
19 years.
19 years.
19 years. So the
19.
medical evaluation, you could have been given a.
Invalid pension. Regular.
Consideration.
What is it for?
Lordship, I'll go through it, whether he has resigned or something else.
Regular discharge, you would have medical, what do you call, medical,
Lordship.
what is it called? Medical?
Evaluation.
Low medical category, Lordship.
No,
Invalid,
a discharge and invalid certificate.
Invalid.
So he would get his pension and all.
Lordship. Obliged.
Leave the.
Item 3.
Please, your lordship. My lord, this matter relates to the my lord pension, non-payment of pension, my lord. Petitioner, my lord, were appointed in 1983. And his service was confirmed on 2000. Thereafter, he retired on 30/4/2020. And pension paper forwarded on my lord 13/12/2023. My lord. Lord, provisional pension, but he has not been paid. He is entitled, my lord.
Pension, have you made a prayer? No.
Yes, your lordship.
Where is that?
My lord, page 16, my lord.
16.
Page 16 in my prayer portion, and in the paragraph, my lord, page 16. Page
No, no, no. Have you made an application before the authorities for provisional pension?
My lord, he has made application, my lord.
Where is that?
On the page, my lord, page 43, 42, 43, and 44. Specifically, provisional pension is not mentioned, my lord. Therefore, pension and other retirement benefits. my lord.
Your name, I forgot.
Jay Bora Lordship on behalf of S. Doctor, your Lordship.
Jay Bora, counsel, appearing on behalf of Mr. S. Lata, any person for PNRD department.
Lordship, I am appearing for 7 and 8 BTC Lordship. Lordship, I kindly record A. Saliha's name for respondent number 2 and 9.
Okay. Mr. A. Salia, and Mr. Joseph for the finance department, appearing for respondent number 2 and 9.
2 and 9. Yes.
Mr. Inayak, any person for the PDC, appearing for respondent number
7 and 8.
7 and 8.
Item 2 and 2.
Respondent three.
Respondent number 3.
AG.
3, you will be appearing. Okay, Miss.
Tinlong on behalf of RK Talukdar.
My council agreement, Mr. R. K. Talukdar. Then it goes for. AG is not a party here.
AG is party, my lord. This year, Director of pension is party, my lord.
No, right of pension will be state government.
My lord, it is a PNRD, my lord.
It's CKS Barwar and the government advocate appearing for respondent number 5 and. No, it will be for 5 and 6. 4 is PNRD.
BDO will come under Panchayat Lordship.
Lordship.
If I'm not mistaken, BDO will come under Panchayat Department also.
Lordship.
So 4 and 5 only Lordship, PC and pension. Generally, Panchayat used to take notice on behalf of BDO.
No, I don't know. Here in my copy, the hospital says number 5 is district commissioner,
5,
6 is director of pension.
4 to
So
Commissioner.
you will appear only for 5 and 6. 4 is
Commissioner Panchayat.
Panchayat. There's something wrong in the cost title. You are giving them different.
5 is pension, 4 is PC.
There's something wrong.
But
You
I've
correct
given a
it.
fair copy, my lord.
No, everybody will have to give a correct.
Oh, yes, Lordship.
I am for 3, 7 and 8. 3 is BTR secretary. 7 is director
3, 7 and
Panchayat
8.
BTC.
3, 7 and 8.
And 8 is BDO Tamulpur Development Block.
Please give them correct copies.
Well-
Otherwise you'll be in the, because they will not get any response by them. When if the response comes, it will be wrong. Maybe non-payment of pension. The present declaration has been filed in Article 26 of the Constitution of India. Notice of motion return of the same date, 5 weeks. Commission shall serve extra copies of the declaration to the State and Department Council in course of the day. Next, pendency of the declaration shall not be a bar for the Commissioner and Secretary to the Government of Assam. So the only Commissioner to the Government of Assam, Panchayat and Rural Development Department. To sanction provisional pension. If there is any delay in the sanctioning of the regular pension to the pensioner. Next, the petitioner shall produce a certified copy of the order before the respondent will bring the order to his notice. List on citizen.
Item 4,
Will you oblige your lordship?
Dear please, your lordship. Hearing your lordship, I am claiming for compassionate allowance as entered under Rule 24 of the Assam Service Pension Rule, your lordship. The husband of the petitioner, he was removed from service, your lordship, 1910 to 2002, Annex 2, page 17. Your lordship, thereafter, I made representation on the wrong advice, they're claiming family pension.
But if you have been removed from service,
Yes,
will you be,
your,
where is the order? Where is the order removal of your husband?
yeah, 17, page 17, your lordship.
17.
Operative, page 19, your lordship.
Okay. Had Mr. I assume that when counsel for the petitioner. As well as Mr. C.K.S. Barot and government advocate appearing for all the respondents,
No, AZ is there also. I cannot appear for AZ.
1 to 4.
1 to 4 also.
1 to
1 to 4. And
8.
the lady was appearing for,
Chandrapura.
No, Talukdar is there.
RK Talukdar can.
Even Talukdar.
what was the name?
RK Talukdar.
No,
RK Talukdar is
That
there.
girl also I don't know.
Okay.
RK Talukdar is there, B.
Huh?
The lordship wants AG.
AG.
Ha, accountant general,
I can.
you can accept notice, huh? Mr. D. Bhattacharya done a standing counsel for the accountant general. A&E, respond within bracket, respond number 5. Next, the husband of the petitioner was removed from service by an order dated 19/10/2002. And thereafter, the husband of the petitioner had died on
14/4/2001.
14/4/2009. Mr. Petitioner has approached this court on Article 226 of the Constitution of India for her entitlement to the
Compassionate allowance.
compassionate allowance
Allowance, Rule 24.
under Rule 24 of the Assam
Assam.
pension rules.
Yes, Assam Service Pension.
Some services within period pension, those rules. Next, if you notice a motion returnable on so and so. Requisite extra copies of the requisition be served on the Rand State and Department Council in course of the day. Next para, the pendency of the requisition shall not be a bar for the respondent before to examine the claim of the petitioner and do the needful. List on so and so.
Much obliged.
7/8/24. Item 5.
IPP follows.
Yes.
My lord, regarding consequential service benefit, retirement benefit, my lord. Retired on subordination, my lord, on 30/11/1996.
You are claiming pension,
Pension, my lord, arrear pension, my lord,
area pension, okay.
as well as other consequential
Sorry,
benefits. my
Mr. N.K. Murray Land Council for the petitioner. For housing, Other?
1, 1, 4, 5, 6, 7.
Mr. P. Nax, standing counsel for the respondent of 1, 4, 5, 6, and 7.
Two lordship, my colleague ASLE has it.
Mr. K. Shadia Leonard,
Standing counsel finance.
then standing counsel finance for respondent number 2.
Yeah.
And Mr. D. Bhattacharya Leonard, standing counsel for respondent number 3. Next one. Leaving non-disbursement of area pension, the present petition has been filed under Article 226 of the Constitution of India. If you notice, it returnable on so and so. Requisite extra copies of the petition be served on the Rand State and Departmental Council in course of the day. Next, the pendency of the petition shall not be barred for the. Who will be the first person to move it? Which respondent shall examine the claim?
Lordship with GMC, Commissioner GMC.
Okay, the respondent of 5 to examine the claim of the petitioner and do the needful for the adjustment of area pension. If the petitioner is found entitled to it.
My lord,
Next one, list on so and so.
my lord, one thing, my lord, page 45, my lord, annexure 6, my lord. That was the gratuity, my lord, already sanctioned way back, my lord, in 2015, my lord. I have only received annexure 7 is the leave encashment, my lord, leave salary, my lord. I have already received, my lord, rupees 19,19,978. That is leave salary, my lord. Annexure 6 is the gratuity, my lord. That is was sanctioned on the same date, my lord, since 2015, my lord. So, my lord, in a theory, my lord, if this court, my lord, wishes, my lord, please, my lord.
I didn't get it. Please repeat again.
Now, way back 2015, my lord, gratuity amount as well as leave salary was sanctioned in my name. Only I received, my lord, leave salary, my lord. Gratuity is pending since then, my lord.
Pension, your pension and gratuity. This is projected to be already sanctioned. In extra copies in course of the day, and this is going to be barred for the respondent right to examine the claim and to disburse it. Same is found due.
I'm obliged, my lord.
If found entitled.
If found due.
No, already received, my lord, other
Please
salary,
don't
my lord.
argue. This is not the time.
Obliged, my lord,
time to
obliged,
argue.
96.
Issue a notice. This is not a prepared time.
Obliged, my lord.
Item 6.
Make please your lord. This petitioner here are all tax collector and road moharers, my lord. Here, my lord, there is no provision, service rule to that effect, but the gazette notification was published on 28/5/2013, incorporating the service
I'm issuing a
rule.
notice.
But
issuing a
in
notice.
those service rules,
I'm issuing a notice
yes, ma'am.
because you are claiming promotion. Right? You're claiming promotion.
Yes, my lord, there is no, yes, my lord. The advertisement has been given, but they have not given the opportunity.
Where is the advertisement?
Advertisement, my lord, notification, annexer 7,
Page,
7,
page.
page, my lord, 131. 131, that is service rule. Then the advertisement was direct recruitment advertisement was annexer 9, page 147.
You're coming out after 7 months.
My lord,
You're coming after 7
no,
months.
no, we submitted one representation that was on 9/2/2003.
But is the exercise over or not over?
It is not complete, my lord. Only advertisement was given.
Mr. Datta, please find out if the process has been closed or not, because last date of application was 10th November.
I'll.
Please find out, because these are to be uploaded in the website.
Yes.
Whether the portal is open or is closed, just find out. 2 o'clock.
No further action.
This
we
advertisement
don't
was
know.
published by
When
state
it
level
is-
recruitment.
when the process is online, we can't say, because it will be creating difficulties. At 2 o'clock, find out.
My lord, this advertisement was published by state level recruitment commission, my lord. Perhaps
Yeah,
for
but-
this, my lord, my friend can take this. I'll take from my department, my lord, but this board is. No, my son.
State level recruitment board.
Yes.
What's a become sorry, B30,
Ah.
become this.
Vikram Chaudhary.
I can inform him.
Please inform me
Yes, yes.
at 2 o'clock. Your authorities will also know.
Yes, yes,
definitely.
I'll take instruction from authority, man.
At 2 o'clock. At 2 o'clock, let him find out.
Item 7.
Then it will fix from at 2.
My lord, report has been furnished, my lord, at page 57.
Page
Page 57.
67,
57.
57.
That's serial number 307.
So what is your
18.90.
disability? Once they say that it's not a benchmark disability, what is the, where is your medical document?
My lord. 39, page 39.
89.
Yes, ma'am.
Under the act, what is the benchmark disability?
40, my lord.
40. Okay. Heard. Where is this document? GMCH document? Where is that?
Page 57.
Page
57.
57. Where is your name? Serial number?
Serial number, my lord. 307.
Pardon me?
307.
307.
307. Jonali Das.
18%.
Hearing impaired. 18 my lord.
Mr. Nayak, who is attending for Mr. Upamanyu?
Yes,
Please find out because last date also I took a negative view of the matter.
yes, Lordship, where the certificate was not issued, Lordship.
Yes. Now, here is also same thing, but the fact that the argument made by Mr. Roy was that once the certificate is issued, unless that is cancelled, the state government would have no authority to revisit it after the disability certificate is granted within the meaning of the Disabilities Act.
Lordship, it was done in pursuance of the OM dated 21 May 2022, Lordship, page 58, Lordship.
21
21st May
May
2022.
2022.
Yes, Lordship. Lordship, page 59 is the relevant portion, Lordship. 5, Lordship. Certificate of disability, Lordship. A person who wants to avail the benefits of reservation will have to submit a certificate of disability issued by a competent authority. Such certificate, in the event of selection of such person for any post, will be subject to such verifications, re-verification as may be decided by the competent authority.
Then, Mr. Roy, your case will be covered by the last judgment which I have passed.
Lordship, on the same issue, Lordship, I have placed one citation by the Supreme Court, Lordship. In a similar situation, Uttar Pradesh, state of Uttar Pradesh constituted a medical board, Lordship, and that was upheld by the Supreme Court.
My lord, a notice may be issued, my lord, give a chance, my lord, on the issue that, my lord.
No, because you see, I am bound by my own orders. Once I have taken a view of that matter, I can just give you some time
My
to
lord, in
make a
similar
permission. I
matter,
can
my
act
lord,
on it.
in similar matter, my lord, the notice has been issued, my lord.
I am not bound by that.
In that case, my lord, your lordship has taken a view because my status has been disputed. I am not come under the 16 Act. Here, my lord,
See, it's the same thing. Once they make an assessment, you see, after that Pune incident,
yes,
how much faith we can have in the certificates, we don't know. It's created a lot of doubt of the manner in which certificates are issued. You have a certificate by a competent authority which says your hearing impairment is 50%. There's another team of doctors who examined you and find your disability to be 18.93%. There's a lot of variation.
but my lord,
It's
there
not
is-
the case of marginal variation where the court can issue notice.
my lord, in this exercise, my- there is a case, my lord. My lord, first medical was held, my lord, they below the disabled person. And the same candidate, when goes to the GMC for renewal, the percentage increase and more than the disability. And when the appeal board constituted, again decrease, my lord. May I submit those documents, those candidate, my lord, and my lord, there is such incidents happen, my lord.
You see,
But there is no variations, Lordship.
it's a case where audiometry tests are done. It's a mere, there are two ways of doing it.
Yes.
One is BERA, correct?
Yes, on the test that I am below
No,
medical
no,
case, my lord.
you see, somebody's assessment may have done it. We can't make in a declaration filed by you. You cannot order the state to undertake an exercise to examine the cases of others.
Same
Correct,
exercise.
their documents are not under challenge. So therefore, that is an exercise the court in your discretion can do. We have a doubt. You have to make submissions on that. That's one. Number two is if in this case, your assessment has been done. That there are two things. Number one, you please come to your petition. Where is the document, assessment document?
57, my lord.
It's a team of several doctors. 1, 2, 3, 4, 5. 5 or 6 doctors have seen that.
But, my lord, the certificate is issued under the statute, my lord. That is hold the field, that is valid across the country, my lord. That certificate should be cancelled, my lord, as per the, my lord, procedure of the act, my lord. Unless until that certificate is not cancelled, my lord. And the authority, they showing the office memorandum, my lord, there is the verification of the, my lord, the verification of the certificate does not means they, my lord, the rewrite the certificate. Document may be verified, my lord, whether it is genuine or not, my lord. The containers of the document, my lord, they cannot write, my lord. What it means, my lord, in the office memorandum, my lord, the verification of the document, verification, re-verification, whether this is genuine or not, my lord. The document verification and the contents of the document verification, writing of the verification, two different things, my lord. Therefore, asking, my lord, notice may be issued, my lord. I will satisfy. And similar matter, my lord, your lordship has been pleased to issue notice, my lord. If, my lord, that is the interpretation of the, my lord, clause 5, my lord, of the office memorandum, my lord. Even in the 2016 Act, my lord, the reassessment is not permissible, my lord. Even if the reassessment is done in temporary disability, my lord, then, my lord, it should be, my lord, the authority, the concerned authority. Concerned authority is the district authority, my lord. Section 57, there is a appellate provision, my lord. This certificate has been issued under section 58, my lord. And as per that section, my lord, the notification has been issued by the government, my lord, to Annexure 1, my lord. Kindly see Annexure 1, my lord, page 38, my lord. There is a appellate authority, my lord. That is if
Yes, on this, Annexure 1, what do you say, Mr. Rachmania?
Annexure 1.
Annexure 1.
Section 59.
Mr. Naik, in terms of this order, the government did not make an inquiry, it did not open an inquiry with regard to the certificates issued by the competent certifying authority.
Lordship.
You are referring to this Ravindra Kumar Sharma.
Yes.
In Ravindra Kumar Sharma, you see paragraph 6.
Lordship, it's very paragraph 2, Lordship. The state government issued an order dated so and so, making a provision for constitution of a fresh medical board in order to verify and assess the disability of the candidates. And that order was under silence, Lordship. And in this petition also, Lordship, clause 5 of the OM is under silence.
Okay, let me examine and pass on this.
Lordship. Otherwise, Lordship may also issue notice also, Lordship, on 14 other matters are coming, Lordship.
Similar matter, my lord.
Okay, let me examine it. Because today I have to rise early, I have to finish the board.
And the notice has been issued this.
Give it.
Other matters are also same, Lordship. Lordship, similar orders for item. Number.
Item numbers
9, 10,
15 and 17.
15 and 17, Lordship.
9, 10, 15 and 17. Okay. Who are appearing in the matters?
Lordship, in all the matters, I am appearing
Please,
for.
please write the names. Please give a slip, we'll record your names.
Yes.
Oblige.
9, 10, 15, 17. 6 organ today. 6.
Item 8.
May I please, your lordship? Not releasing the subsistence allowance and the pensionary benefit, as well as other retired benefit, lordship. In this regard, petitioner have earlier occasion proposed before this honorable court. This honorable court was directed to the respondent authority to release the subsistence allowance and pensionary benefit, lordship. Annexure 38, lordship, page 31, lordship.
Then you should file a contempt because your liberated it would not lie.
Lordship, already time is over. That is why, lordship, I have filed again a writ petition, lordship.
Second interpretation would not lie. The orders passed by this bench saying that liberated it would not lie. You got to file a contempt.
Lordship, contempt time is already over, Lordship. That is why, Lordship.
Lordship, pension matter, Lordship. One representation is at 7/2/2023, Lordship. Lordship, may kindly dispose of this matter in the light of the earlier order, Lordship, and I will peruse the matter with the authority, Lordship. Let them take a decision, Lordship.
Okay. But Mr.
P.K. Gogoi, Lordship.
P.K. Gogoi, the counsel for the petitioner, and Mr. P. Nayak, and it's standing counsel for the
All the
Uh,
respondents, Lordship.
standing counsel for all the respondents.
GMC, Lordship.
Next, paragraph. Case of the petitioner is that during the pendency of uh, there's no disciplinary proceeding against you. There's no disciplinary proceeding against you.
Lordship.
This
Is
claim,
there any disciplinary proceeding against you?
Yes, Lordship. There was not any initiated by the department,
no,
Lordship.
initiation was there, Lordship. It's his own statement, Lordship.
Paragraph 3, Lordship, earlier order, Lordship. 33 page, Lordship.
In the
has been
synopsis
revealed
itself,
there-
Lordship, the Commissioner GMC Guwahati on 16/3/2013 issued an order whereby informed the petitioner's husband that disciplinary proceeding was drawn up against him.
Say that the husband of the petitioner had died on 7/2/2013. At the relevant time, he was working as an upper division assistant, and he was placed under suspension on the allegation of fraudulent withdrawal of GMC fund from the Guwahati Municipal Corporation account number 108-236-42869. And it is also projected that the disciplinary proceeding drawn up against the was drawn up against the husband of the petitioner, Mr. Bhava, during the pendency of the said proceedings. The husband of the petitioner had superannuated on 7/2/2013. Full stop. Thereafter, the husband of the petitioner had approached this court. He died when?
Lordship. 15/6/2021, Lordship. Annexure F, Lordship.
Okay.
Annexure G, Lordship, page 30, Lordship. 15/7/2021, Lordship.
Okay, the petitioner approached this court by filing WPC 7037 of 2017 And during the pendency of the writ petition, the husband of the petitioner had died on, what is the date?
15/7/2021.
15/7/2021, and thereafter the present petitioner was substituted. And this court by order dated 30 January 2023 disposed of the petition with a direction.
Lordship 15/6/2023, Lordship. Date of death, Lordship. 15/6/2023, Lordship, as per record of the Annexure G, Lordship.
15/6/23.
Yes, Lordship. 21, Lordship, 21, Lordship, it is not visible. 21, Lordship. Actually,
video
it
brief and
is
then come.
not visible, Lordship.
Please
21,
video brief and
Lordship.
then come. What is the date?
15/6/21.
What is the date?
15/6/21, Lordship. 2021, Lordship.
15/6/2021. Present petitioner was substituted and this court by order dated 30 January 2023 passed in WPC 7037 of 2017 allowed the writ petition by directing the respondents to verify as to whether the petitioner has been, the husband of the petitioner has been paid his subsistence allowance during the period of his suspension, and whether the petitioner has been paid pension as well as pensionary benefits. So it was also provided that if upon verification, the husband of the petitioner was not paid subsistence allowance, the respondents were to pay the subsistence allowance for the period of suspension, as well as area pension and other pensionary benefits. The said exercise was required to be done within a period of 2 months. The petitioner had submitted a representation on 7/2/2023 as no disbursement has been made to the petitioner. The present petition has been filed under Article 226 of the Constitution of India. But the lowest standing counsel for the GMC in the matter. Next paragraph. As the presentation of the petitioner dated 7/2/2023 is by the petitioner to the commissioner, GMC has not been responded to. The court is inclined to direct the commissioner,
Lordship, I am saying this is a representation of 2023. Probably it was disposed of, copy may not have been served to the petitioner. That may be one situation, or it probably it has not been disposed of at all, Lordship. So Lordship may direct if in the meantime this has not been disposed of, authority will dispose of this order. If in the meantime disposed of, then a copy may be served to the petitioner.
Okay. That will dispose of the said representation. If not, if already not disposed of, and a copy thereof is served on the petitioner. So the said exercise shall be done within a period of 1 month from the date of
Lordship.
service of certified copy of this order. Next paragraph. It is also provided that if the petitioner is found entitled to the area subsistence allowance of the of her husband from a pension if any due from the date of superannuation till his death, and family pension for the petitioner who is the wife of late Padma Ram Kalita, the ex-employee of the GMC. The same shall also be disbursed within an outer period of 3 months. Petition stands disposed of in the
Just
motion
1 lakh
stage
lot.
without issuance of notice on the respondents.
If she is not entitled, authority will pass a speaking order to that regard, that line only. Lordship.
Because we have already said that. You dispose
she
of
is
any
entitled,
fine,
yes.
if amount is found due, then it will be disbursed.
Lordship.
I'll oblige, Lordship.
Yes, 11.
Item 11.
My pleasure. This is a case, my lord. It will show that if the mighty state decides to go after a citizen, it can make life hell for it. But for the purpose of motion, my lord, I'm not troubling your lordship with the long facts. Just to briefly indicate. So what had happened was he was one of this, he was the senior most joint controller of legal metrology. But to prevent his promotion, all this problem first started. There was one blue-eyed person. To favor him, there were various manipulations done, multiple rounds of litigations happened. Ultimately, interim orders were passed in my favor. That is how I continued as a in-charge controller for some time. Now, finally, when they realized that this is not proving fruitful because of your the interference caused by this honorable court, they issued a show cause notice, alleging that I've been caught taking a bribe. That is again a separate chapter altogether. Now based on that, our proceeding was initiated. Ultimately, if your lordship will kindly turn to what is relevant for this petition, if your lordship will kindly turn to page 110. This was the order of penalty that was passed. Your lordship will kindly turn to page 110.
Yes.
Right at the bottom of that page, your lordship will find the penalty imposed. After careful examination of all the facts and findings in the matter, the Governor of Assam, therefore, in exercise of powers conferred under Rule 21 of the Assam Services Pension Rules 1969, is pleased to order that 25% of gross amount of pension admissible to Sachindranath Busso, the then Joint Controller of Legal Metrology and then Controller of Legal Metrology in charge, Assam, be withheld permanently. This is the penalty imposed. We filed a writ petition, and the order passed thereon is at page 112. Relevant portion your lordship will find at page 114. This order imposing penalty has been stayed.
Yes.
Till the next returnable date, the notification dated 1/3/24 shall remain suspended. I served this copy, and immediately thereafter, what they do is this. Page 190. This is, with greatest respect, this is atrocious. In exercise of the provisions as prescribed under FR 54 of the FRNSR, read with Rule 61 of the Assam Services Pension Rules 1969, the period of suspension with effect from 8/7/22 to 31/12/22 in respect of Sachindranath Busso, the then Joint Controller of Legal Metrology and so, is hereby treated as on earned leave, subject to admission. What they have done is, the entire earned leave that had accumulated during my entire service career, this is an additional penalty they are imposing. How can they do it? They have already imposed the penalty. Will it not amount to double jeopardy? And in any case, if your lordship kindly takes up the provisions that they have referred to, these are not even applicable. If your lordship first takes up the pension rules of 1969, This order has been purported to be issued under Rule 61, read with FR 54.
Yes.
Bare perusal will show that these provisions are not even applicable. First, your lordship will take up Rule 61 of the pension rules.
Yes.
Time passed under suspension pending inquiry into conduct counts in full, where on conclusion of the inquiry, the government servant has been fully exonerated or the suspension is held to have been wholly unjustified. In other cases, the period of suspension does not count unless the authority competent to pass orders under FR 54 expressly declares at the time that it shall count, and then it shall count only to such extent as the competent authority may declare. Now we have to fall back on FR 54. If your lordship takes up FR 54, your lordship will find
Fundamental. Fundamental law.
your lordship will find that FR 54 pertains to a situation only when a major penalty of dismissal, removal, or compulsory retirement is passed. It does not pertain to a minor penalty as in my case.
What was the penalty imposed in your case?
25% of withholding of pension. And if your lordship peruses your lordship will kindly turn to FR 58 for a moment.
Just a moment.
Your lordship is aware that earned leave and the encashment in lieu of thereof is an entitlement actually under FR 58, read with the leave rules. And this is a right which has accrued over a period of his entire service career, which cannot be taken away like this.
FR
58. Unless in any case it be otherwise distinctly provided in section 6 of this chapter, the rules in sections 1 to 5 of this chapter shall apply to all government servants to whom the fundamental rules as a whole apply, provided that a government servant who elected the leave rules of the civil service regulations as they stood, whether before or after the 29th July 2020, shall continue to be governed. We are not concerned with this. And provided further that the leave rules 1934 shall apply to the classes of persons specified therein. Now, if your lordship will kindly turn to the leave rules, which your lordship will find in the same FRSR. If we are holding the same book, it would be I don't know whether we are holding the same book. In the book that I am holding, it starts at page 392.
It is appendix?
Appendix 11.
11. Yes.
Has my lord got the leave rules?
Yes.
Your lordship will find that this is framed under Fundamental Rule 58. Your lordship kindly turns to sub-rule 2 of Rule 3. Earned leave is defined. Earned leave means leave earned as per provisions of Rule 9 of these rules. Now, if your lordship kindly turns to Rule 9, your lordship will find that 9(1)(b) provides that during the service career of a government servant, he can accumulate up to 240 days of earned leave. This has undergone an amendment. Presently, we have annexed the amendment
Which rule you are saying that?
9B, my lord.
B. Yes.
Up to 240 days can be accumulated by a government servant. This has undergone an amendment. And that amendment, your lordship will find at page 117 of the writ petition. This 240 days has been increased to 300 days. We have annexed that amendment.
Yes.
That amendment, your lordship will find at page 117. Type copy is at 117, the original is at 118. This is just to show that even that 240 days has been increased to 300 days.
Yes, Mr. Nath.
Now, my lord, just one more thing I need to point out. Under these rules, the government has issued a notification that these earned leave that accumulates over which your lordship is aware, at the time of retirement, I can encash up to a particular limit. That is under a notification dated 19/7/78, which is again it is part of the leave rules itself. Your lordship will find it is marked as Annexure A. There's a notification dated 19/7/78. It should be immediately after Rule 7.
Yes.
The
Yes.
government of Assam have had under consideration for some time the question of grant of cash equivalent for unutilized earned leave at the credit of the state government employees. The matter has been carefully considered, and the governor of Assam is pleased to decide that the state government servants may be paid cash equivalent of leave salary in respect of the period of earned leave at their credit at the time of retirement on superannuation. And para 3A says that out of those 300 days, I can have an encashment in lieu of the earned leave for a period of 180 days. Now, if they wipe out by virtue of this impugned order, this entire accumulation, which will come to about 10 to 12 lakhs, that gets wiped out by a stroke of a pen. And it will amount to imposing a second penalty, and that too without any notice. How can they do it? And for the same, your lordship is aware of the law, but for the same charges, I cannot be penalized twice. It will violate the spirit of Article 22. So therefore, my lord, looked at from all counts, and even the colorable exercise is also absolutely apparent on the face of the record. And based on this, now they have held back my pension also. I have retired in 23 itself. I am not getting any of these benefits.
Well, the penalty order, lordship at page 110, lordship has seen. But the departmental proceeding was initiated when he was in service, but in the meantime he retired, so it got converted under Rule 21 of the pension rules. But at this stage, ultimately after the retirement of the incumbent, the penalty was that 25% of the pension will be withheld. And now, the period of absence during which he was not in service, during the departmental proceeding after his arrest and the retirement, that has to be treated as per the rules. That has to be treated. Ultimately, an order has to be passed. That has been passed on 17th of May. But at this stage, kindly give us some time. We'll file an affidavit in the matter. Lordship may keep the matter immediately after the vacations, and give us an opportunity to file the affidavit, bringing on record under what circumstances this has been done.
No, but there is in a departmental proceeding, the penalty of 25% is at page. Which page?
110, Lord.
110.
Lordship. In that proceeding, kindly see paragraph 4, fourth paragraph in the order. Whereas the delinquent officer, Sri Shoshendranath Boisho, had retired from government service on attaining the age of superannuation on 31/12/22, and therefore the department informed the state inquiry officer that the departmental proceeding is to be treated under the purview of Rule 21 of the Assam Services Pension Rules 1969. And thereafter, the inquiry report has been submitted and the inquiry report submitted by the state inquiry officer has been furnished to Sri Sachindranath Bosso in the light of Rule 9A of the rules 1964 against the delinquent officer, and has submitted his reply, which was not found satisfactory. And whereas the Assam Public Service Commission was consulted as prescribed under Rule 21D of Assam Services Pension Rule 1969 regarding penalty of withholding of 25%. Here the government is the rule provides that the government can take a decision as regard withholding of full pension or any amount of pension. That has been taken here. But here the period of absence from service that has not been treated. So therefore the second order on 17/5 was passed.
Can that be done?
Yes, my lord. But that can be. Ultimately, that period of absence that has to be regularized.
Can't be, because if you have issued a notification that ends the matter, you have not kept it. This you have not reserved your right to pass orders later on.
Well, the period when the person was absent, because of
He
this,
was not absent, he was suspended.
yes, my lord, he was not in service.
Suspended,
He was not
I
in
don't know if
service.
there is a government policy that once a suspended man can attend office.
No, my lord, I'm just referring that when he was suspended, my lord, he was not in service. So that period has to be ultimately regularized.
No, how
So
do you say that? On suspension, he is not in service.
but that period has to be regularized. Either Malad, now what they have prayed, they said that the order has to be set aside and he should be treated as in service on duty, so that he will get the benefit. That is what the case is about. Malad, kindly see, the
No, because you have not passed the order to that
Yeah.
effect. Therefore, he has come to court seeking that
that
remedy which is not passed.
is period under suspension should be treated as on duty. That is the ultimate case of the petitioner. Malad. Here, Malad, the government has considered the period under suspension to be on earned leave. That is the order passed by the authority, and the prayer of the petitioner is that period should be treated as on duty. That is the ultimate prayer in this case. If it is treated as on duty, not on earned leave, then he will get the benefit of earned leave. That is his case. At this stage, kindly, Malad, give us some time, Malad. We'll respond, Malad,
What this
immediately
has to
after
be
the.
stayed. You
Lordship.
record the
Lordship, just one submission. Lordship, may kindly see prayer C. Lordship.
here,
Prayer C.
C.
Mandamus shall not be issued directing the respondent authorities to treat the period of suspension with effect from 8/7/2022 to 31/12/2022 as on duty.
As on duty.
So that is the claim of the petitioner.
Yes.
Now, Lordship, one decision was taken pursuant to a departmental proceeding, Lordship, that is permanently withholding 25% of the pension. A second decision has to be taken under FRSR 54, whether the suspension period is to be regularized or not. So this is not neither it is a double jeopardy, Lordship, it is not a double punishment, Lordship. Earlier one was a decision
You're not required to pass an order in the departmental proceeding itself.
under 54, Lordship, while we were finalizing the pension, we have to take a decision whether his suspension period is to be regularized or not. Authority simply took a decision not to regularize and consider it as a on earned leave, Lordship. So this is a simple decision, Lordship, under FRSR 54. So let them challenge that decision, Lordship. That is the only issue.
That is under challenge.
That's under challenge.
We have challenged it.
Malad, in my respectful submission, Malad, I have one more submission, Malad. Malad, if this order of 17th of May is stayed by your lordship, Lord, ultimately the effect would be from 8/7/22 to 31/12/22. This period will not be treated as anything, Malad. Ultimately, government is not in a position to do anything and take any decision on that. Now, Malad, they have treated this period as an earned leave. Otherwise, that will be again a Malad,
Earned leave is a entitlement that has accrued to me under the rules. It is a vested and accrued right which cannot be retrospectively taken away. That is the settled proposition of law.
That lordship will finally decide. But the staying of this order, what benefit ultimately he will get, Malad? That is what I am indicating. Sir. That ultimately the period has to be regularized for the purpose of pension and all these things.
Their argument is against FR 54(2). That the authority competent to order reinstatement is of the opinion the government servant who has dismissed, removed so and so has been fully exonerated. The government servant shall be paid full pay and allowances. The termination proceeding in so and so has been delayed due to so and so attributable to the government. So and so. It does not say about it does not say about a second decision.
Well, the page 32, the prayer portion, this itself indicates, my lord. Ultimately, the period under suspension is to be treated as something, my lord. It has to be regularized. As on duty, they said that it should be treated as on duty. And the authority, they have taken a decision that it should be treated as on earned leave. That is the main dispute, my lord. If it is treated as on duty, then he will get the earned leave benefit for the earned leave. And if it is earned leave, then the remaining earned leave, he will get the benefit. Not for from 8/7/22 to 31/12/22 for 5 months.
But Sai Chaudhary, Senior Counsel, assisted by Mr. S. Vishwakarma and
T. Das.
T. Das, and counsel for the petitioner, also heard
For 1, 2, and 3, my lord.
Mr. D. Nath and its senior committee advocate appearing for respondent was 1, 2, and 3,
I'm appearing for 4, Lord.
and Mr. P. Nayak Leonard, standing counsel for the finance department, representing respondent number 4, and Mr. S. K. Mehdi Leonard, standing counsel for the respondent number 5. The case of the petitioner is that while serving as a controller in charge of the legal, what is your office, Commissioner of Legal Metrology?
Legal metrology.
Legal Metrology, Assam. On an allegation of taking bribe and misusing his official capacity, he was arrested on 8/7/2022 and he was suspended with effect from the same date, and while under suspension, he had superannuated on 31/12/2022. In the meanwhile, in the disciplinary proceeding drawn up against the petitioner, by an order dated 1/3/2024, a punishment of withholding of 25% of the gross pension was ordered. Full stop. The said order dated 1/3/2024 has been assailed by the petitioner by filing WPC 1907 of 2024, and the said order dated 1/3/2024 was suspended by an order passed by this court on 5/4/2024. Full stop. The said order was communicated to the respondent authorities, to the competent authority. Full stop. Thereafter, by the impugn notification dated 17/5/2024, within bracket annexure U, bracket closed. The Secretary to the Government of Assam, Food, Public Distribution and Consumer Affairs Department had ordered that the period of suspension with effect from 8/7/2022 to 31/12/2022 shall be treated as earned leave. The said order is under challenge in this writ petition filed under Article 226 of the Constitution of India. If you notice a motion returnable. If you notice a motion including notice on the prayer for interim relief returnable on how much time?
Well, Lordship may give us 4 weeks time. Kindly keep it after the reopening, my lord. In the meantime, we'll file.
Yes, for requisite extra copies of the writ petition we file. We furnish to the learned state and department council in within 2 days.
By study. 22 তারিখ 26 তারিখ 22 তারিখ 26 তারিখ
ও 22 তারিখ মনে হয় 24 তারিখ
So the impugn notification dated 17/5/2024 and appropriation of appropriation, if any, of the what is it called? What leave is that called? Leave salary. Appropriation of leave salary.
Leave and encashment of leave salary.
Earned leave encashment.
Earned leave encashment.
Encashment of leave salary.
If any, shall be subject to further orders that may be passed on the next date.
But this may be tagged with the other writ petition.
Okay, list on any date is given in the earlier date in the other matter?
No. No date is fixed in that.
Okay. List along with
WPC 1907 of
WPC 1907
of 24.
of 2024. Apparently it doesn't.
This is a statutory accumulation, Mallo. How can they take it away like this?
Doesn't appear to be right.
Obliged.
12.
Therefore, personal package report associated, but the TCC has not been attested. DLC get later than equal even.
What is the date of death?
Date of death, 3/7/2014, madam.
2014, we are not entertaining writ petition at this stage.
My lord, in the same month, that is 23rd July 2024, prayer petition was made for engagement as, appointment on compassionate ground was sought for on 23rd July 2014, 2014. In the same month. And subsequently, his petition has been not considered by the concerned authority. After learning all about it, the petitioner has submitted his subsequent petition on 27/3/2023, and copies of which also upon the all respondents. Despite that, no information was given to him. Finding no alternative, he again subsequent his last representation on 28/3/2023, my lord. And after waiting for last 6 months, by giving his last representation. No information has been given to him. Consequently, this case has arisen. One thing, my lord, during the pendency of this representation, he has been engaged casually by the concerned department as Jal Mitra, and he has been still serving casually.
No, but this 2014 is 10 years down the line.
My lord,
We
quite
we
right.
can't we dismiss your petition.
My lord, if this honorable court may be pleased to pursue the judgment pronounced by the Patna High Court in terms of the decision of the Supreme Court, Honorable Supreme Court, that has been disposed of
Please pass
on
it,
2nd May 2024.
pass it on.
Yes, my lord. Partly similar matter, my lord.
Okay. Heard Mr. M.S. Adil and counsel for the petitioner. Also heard Mr. C.K.S. Barwat and the government advocate, appearing for respondent numbers.
For respondent number, let's say, 1, 2, 3, 4, 8 and 9.
1, 2, 3, 4, 8, and 9. And
I mean, I'm hearing from
Mr. P. Nayak and his technicals for the finance department representing respondent number 9.
5.
Oh, sorry, 5. And Ms.
7, 10 and 11 and Kalita.
and Ms. M. Kadikar and a standing counsel for PHE representing respondent numbers 6, 2.
7, 10 and 11.
6 also,
Yes, Your Lordship.
Public
6, 7,
10 and 11.
10 and 11. Mr. C.K. Barba is for respondent number 1, 8 and
1,
9.
3, 4, 8 and 9.
1, 2, 3, 4, 8 and 9. Okay.
So I have one submission to make, Your Lordship. His case is the placing of his case. His case is the placing of his case by the DLC for the SLC. Also in the petition, also I have not found the minutes of meeting of the DLC, what the DLC has sold.
Well, this okay is making a statement. He may not have the documents. We have not given. Where is that statement?
DLC
For the page number,
नहीं दिया मत DLC की decision issue भी देना नहीं
that's what, after DLC. If DLC rejects his case, then only it will place before the SLC.
He's not saying anything. He's saying that his application was forwarded. And it was given to the petitioner, but he does not know about that. That's what he says.
So we will get an instruction from DLC, Lordship, what has happened after that.
In brief, the case of the petitioner is that his father late Faijor Rahman was serving in the PHE Rangia division as grade 4 Khalasi, and he died in harness on 3/7/2014 due to illness. Full stop. The petitioner applied for appointment on compassionate ground on 23/7/2014, which was forwarded to the concerned authorities along with the proposal for engagement of the petitioner. On compassionate ground. First of, however, the petitioner has not been informed about the status of his application as to whether his application has been considered or rejected. First of, petitioner projects that he has been regularly pursuing the matter and has also submitted a representation on 27/3/2023 followed by another representation dated 28/11/2023. First, it is also projected that since the year 2014, the petitioner has been engaged as a Jal Mitra at Deodwar, DEODUAR, TWSS,
Take over your PhD.
and he has also undertaken
Will you get your poster? Get your poster. Get.
training course of 10 days at ITI Rangia. For waterworks under the PHE department. As the candidature of the petitioner has not been considered, the present writ petition has been filed in Article 226 of the Constitution of India. Next, in support of his contention, the learned counsel for the petitioner has referred to the decision of the High Court of Patna in the case of Amrendra AM, REN, DRA, Kumar versus State of Bihar and others, CWJ case number 16803 of 2012, decided on 2/5/2024.
in connection with the claim, the relief claimed by the petitioner in this writ petition, the court is of the considered opinion that the inordinate delay in consideration of the application for the petitioner, the petitioner is disentitled to any consideration for appointment on compassionate ground. In this regard, the court finds support from the decision of the Supreme Court of India in the case of State of West Bengal versus Debabrata Tiwari, EIR 2023 SC 1467, equivalent to within bracket 2023 bracket to 0 Supreme within bracket SC 191, wherein it has been held that inordinate delay, even on part of the state, to consider the application would make the petitioner disentitled for consideration for appointment on compassionate ground. Next, the observations made by the Supreme Court of India in paragraph 7.4 and 7.5 of the case of Debabrata Tiwari within bracket Supra is quoted below. Next paragraph. The case of Amrendra Kumar within bracket Supra, cited by the then counsel for the petitioner, would not help the petitioner in any way because of the distinguishing facts of the said case. First off, as per the facts narrated in the said order, the chief engineer, who was the appointing authority, had appointed the petitioner therein on compassionate ground. By an order dated uh, 6/7/1996. The petitioner joined on the same day, and his service was confirmed by a memo dated 13/8/1996. Thereafter, the said appointment order was cancelled by the Secretary, Water Resource Department, Government of Bihar, by a memo dated 17/2/1997. Thereafter, the petitioner therein was appointed afresh, and his appointment was confirmed by memo dated 9/4/1997. The state, in response to the writ petition, had submitted through its standing council, to the state council, that the district compassionate appointment committee had recommended the name of the petitioner for appointment on compassionate ground to the post of accounts clerk, and pursuant to the same, the petitioner had thereafter joined the Water Resource Department on 6/7/1996. Stop. It is under the set factual matrix. The High Court of Patna had found the petitioner to have been appointed on 6/7/1996 on the recommendation made by the District Compassionate Appointment Committee, and therefore referring to the decision of Devavrata Tiwari within bracket Supra, had held that the order dated 11/2/2011 passed by the Principal Secretary to the Government of Bihar Water Resource Department was not sustainable by which the petitioner was removed from service. And thereupon a direction was issued to the respondent authorities to consider the case of the petitioner afresh and take a decision within 6 months. Next, the above narration of brief facts of the case of Amrendra Kumar within bracket Supra show that the said facts are distinguished from the facts of the present case. Full stop. Next paragraph. In the light of the judgment of the Supreme Court of India in the case of Devavrata Tiwari within bracket Supra, the relevant portion of which relevant part thereof whereof is quoted herein before, the court is of the considered opinion that in light of the said ratio, in light of the ratio of the said case, the petitioner is entitled to a consideration for appointment on compassionate ground. Next para, moreover, this court in the case of Achyut Ranjan Das versus State of Assam and others, under Principle 10, formulated under paragraph 7 thereof, has held that if an application remains pending for a period of 2 years, shall require no further consideration, and the said principles have also been incorporated in the OM dated 1/6/2015 issued by the Government of Assam, under under Principle 10 thereof. This is numerical 10, X, the application which has remained pending for 2 years require no further consideration.
Next one. Therefore, the writ petition fails and the same is dismissed.
My lord, with regard to the irregular appointment, I think, I'm sorry, casual appointment of the petitioner.
We are not saying anything. If you can continue with that, Jalmitra is nothing to do with the state.
One
That
reason
is
may be
being,
given.
that is being appointed by the, what you call, user committee. You
In
continue
the,
that.
in the same year he was engaged, my lord, and consequently he has been serving,
We are not interfering with that appointment.
my lord.
You may continue with that. You have got nothing to say. But that is by user committee. It's not by the state.
If it is elaborated in the present judgment, my lord,
Pardon me?
if this point of view has been elaborated in the present judgment, that will benefit me, my lord.
Okay, next paragraph. This order shall not cause any prejudice to the petitioner while serving as Jalmitra in the under the PHE schemes.
Taken down and he could not approach the office for fulfilling the formalities of
Mrs. Thagre, you are in your situation.
my lord.
What has happened is that you approach the district judge for a
Yes, my lord.
succession.
As per the direction of the office, my lord.
That's okay.
Yes, my
But
lord.
once that is rejected,
Yes, my lord. There is no provision, my lord, under the Indian Succession Act for grant of my lord family pension, my lord. That is why, my lord. Observation is made by the my lord learned district judge, my lord. As per their direction, she approached the my lord the district learned district judge, my lord. That is why she approached before this honorable court.
okay, then I will issue a notice.
Yes, ma'am.
Heard Mrs. Ganesh Thagre and counsel for the petitioner. You are appealing for?
All the respondents, lordship, Arbora.
Mrs. Arbora, that it's responsible for the agriculture department, appearing for the respondents. Let's go. Claiming non-payment of family pension and dues under the GIS scheme lying undisbursed in the name of late Nalini Mohan Das, the husband of the petitioner. The present petition has been filed under Article 226 of the Constitution of India. So the petitioner claims that after the death of her husband's first wife on 12/12, she had married. But this is she had married late Nalini Mohan Das, who is then alive, on 12/12/2008 under Special Marriage Act, and out of their wedlock, she also has a 15-year-old daughter. It's submitted that the husband of the petitioner had superannuated on 31/1/2015. Expiration notice returnable on the date after 5 weeks. The petitioner says requisite extra copies of the petition be served on the London Department of Council in the course of the day. Next paragraph. The pendency of the writ petition shall not be a bar for the responding authorities to consider the claim of the petitioner and to make disbursement if she is found entitled to the release.
7th of August. Item 14.
Yes. No, please, Doctor.
In this petition, Your Lordship, I primarily challenge the constitution of a user committee of water purification plant, my lord, under Jal Jeevan Mission, my lord. And my case is that, my lord, in the committee, my lords, a huge number of outsider of the Yarmark area members were.
How is it constituted? This user committee is constituted in
Actually, user
manner?
committees were constituted by following the Gaon Sabha, my lord.
Where is that?
The user committee is at page, my lord, page number 31, my lord.
No, this is your,
Yes, my lord.
this is your committee. No.
No,
What is
it's
the-
not
what
my
is the
committee.
scheme? What is the scheme?
Scheme is Jal Jeevan scheme, my lord, for to constructing.
No, where is that scheme? For appointment of a user committee, there must be a scheme of the.
Yes, my lord, there is a scheme, my lord, there is a guideline, my lord. In that guideline, my lord, it's stated that for the
Where is-
management and
Where is that?
it's a voluminous, my lord, it's not in the petition, it's a voluminous, your
Oh,
lord.
no, the most voluminous record which I am now considering
My lord,
is running into about 3,000 pages.
yes, my lord.
I made it CV, I am writing that judgment.
Can your lordship?
I'm not afraid with volume,
Can
but
you,
you have to show that you are.
can your lordship may fix this matter on the next week? I will supply a copy, my lord.
Because I have to
My-
know that. You have a copy of the scheme, no?
Right now.
Only I have a copy of this, my lord, only one copy, my lord.
Mark that of the constitution, which page is that? Mark it.
Well, nothing is regarding the constitution, but it is stated that in village infrastructure development and management will be the responsibility of Gram Panchayat and oblique or its subcommittees, that is VWSC, Pani Samiti and user group, my lord.
Let's show that.
Rajiv.
Mr. Dutta, if it is to be done by the Gram Panchayat. Is it so? Mr. Dutta? It is to be done by the Gram Panchayat, the user committee.
Not exactly, I think.
It is written as the Gaon Panchayat and oblique or its subcommittee, that
Just
is.
pass that on. Unless I read, I won't understand.
The second column, my lord.
You see, you have a document, you don't read it. And I've got this, how much time I have spent? How much time I have spent after receipt of this?
5 minutes, 7 minutes.
5 minutes? No. This reading did not take 5 minutes. I don't think it will take more than 1.5 minutes to read this. By going through this, I have found the paragraph where constitution is there. So next time, don't tell us that this is voluminous. This reading of this took 1.5 minutes. Yes, Collector, issue notice here. Had Hussain, yeah, Hussain and petitioner. Also had.
Okay, am I with you?
Yes. CGC will be there.
I'm waiting for 1, 2, 3.
CGC appearing corresponding by
1, 2, and 3.
1, 2, and 3.
Yes, sir.
And this, and Kalita, and then standing counsel for the EHE representing respondent numbers
7, 9,
4,
13,
7, 9,
13, your lordship.
14,
13,
13, 14.
not 14, your lordship. 14 is water resource department.
What's it, 13?
And as regards respondent number 12, I'm not sure this post exists, your lordship. Chief Executive Engineer. There's only the chief engineer and executive engineers.
Okay. She also submits that she is not aware of the authority. This is impleted as respondent 10, 12. And accordingly, she accordingly, she is allowed to take instructions as to whether the respondent 12 authority exists or not. This one, you also heard Mr. S. Datar on it, standing also for the PNRD department, representing respondent number 5, and Mr. C. Sharma on it, standing also for the water resource department, representing respondent numbers 6, 8, 6, 8, and 14.
Then it's in.
May I submit one thing?
Yes. Yes. Who's 16 also you can appear, I think.
16 I can appeal.
16?
I can appeal.
The 16 is. Yes.
My lord, as this is relating to Gaon Panchayat matter. Gaon Panchayat, at least BDO and the secretary is the necessary party in this matter.
Okay, record your submission. The run is standing also for the PNRD department has submitted that as the matter relates to the respondent number 15 Gaon Panchayat, the jurisdiction, video and
Secretary of the Gaon Panchayat.
secretary of the Gaon Panchayat are also necessary parties. The land council for the petitioner shall take note of the said submissions. Next part. It was projected that Who are outside your village?
My lord,
Who are the persons outside your village?
there are, my lord. I have written everything, my lord, in. My lord, the president is outside from the village area, my lord, Sadiqud Jamal.
No, respondent, just tell us.
My lord,
respondent number.
respondent number 70. My lord, 20, 21, 20, they are outside the covered area, my lord. 335 number of houses are included in the area. They are not fall within that,
Oh, no, then we'll have to dismiss your petition.
my lord.
Then your petition will not be maintainable. These people are in the same village where you are residing.
There are two-
Altiani.
There are two plant, my lord, in the said village, my lord. And the area was distributed between these two plant, my lord.
No, but it's a
And
Gram Panchayat
secondly,
when they are appointing someone.
and secondly, my lord, there is another thing, my
No,
lord.
in this scheme, there is nothing called that under this scheme, there can be a bifurcation of the.
There is another thing,
Panchayat.
there is another thing, my lord. Herein, my lord, all the members are not elected in the Gaon Sabha, my lord. Some of elected thereafter, understandably, my lord. Even in the user, my lord, user committee, my lord, it is reflected, use of, my lord, eraser, my lord.
No, you are not challenging their election.
My lord,
Please come to your prayer. What is your prayer? You grant the appointment, the user committee. You're not saying that their elections are.
my lord, I have
declared-
stated in the petition, I have taken the plea, my lord. And in this regard, there are complaint before the authority also, my lord. That complaints are not taken.
No,
into-
they are they are the members of the same village.
But they are outside the area.
No, then you satisfy us from the, you read at 2 o'clock and then come back.
My
In
lord,
this
in,
scheme, there is nothing called the scheme wise appointment of user
my lord,
committee.
in next week, my lord.
Just after a week, as straight for the design council for the petition.
Okay.
Item 16.
Yes, Mr. Das.
No, you can dismiss him, my lord. He was appointed.
Notice,
Your lordship has to issue a notice. Only one thing, your lordship will issue a notice. Kindly see, there is a parameter clause in CIS if is concerned, and this court, because it's a case of bigamy. He was dismissed on the ground of bigamy. Now, there is one judgment of this court, writ appeal. See at page 180, 90,
175, yes.
190. At para 12, because single bench has set aside that order and said it is harsh, and ultimately Union of India has preferred an appeal before division bench. At page 190, kindly see para 12. Accordingly, for the reason discussed above, we are of the dismissal with petition of service will amount by disproportional harsh punishment. We uphold the order passed by Ranjit Singh in setting aside dismissal. However, for different reasons discussed above, direct disciplinary order may pass any other lesser penalty or a petition other than the penalty of dismissal. So, lordship, let a notice be issued and eliminate an attempt to take instruction on this.
This page 175 is different from 185 or same? 175 and 185 are different or same? 175 and 185. Same or different?
Different. 175
and 185.
Yes, 185 is all same.
Same.
Yes, same.
Okay.
Same.
Okay, this 175 I had seen.
Yes.
But Mr. D. Das, the senior counsel, assistant, Mr. P. R. Sharma, the counsel for the petitioner. You're appealing for all?
1, 2 and 3, man.
Mr. A.
MR Adhikari.
MR Adhikari. I'm sorry, I'm so forgetful.
My
Every day I ask names and then I forget. MR Adhikari, then it's CC appearing for the respondents.
1, 2, and 3.
Yeah, the respondent numbers 1, 2, and 3. The order dated 6/10/2023, passed by the disciplinary authority, by which the service of the petitioner was terminated. And the order dated 18/12/2023. No, sorry, 2/2/2022, thereby rejecting the appeal of the petitioner, are assailed in this petition filed under Article 226 of the Constitution of India. You should notice returnable on same day. 5 weeks.
7/8/24.
Requisite extra copies of the requisition is served on the learned CGC within 2 days. So it may be stated that the learned senior counsel for the petitioner is placing reliance on judgment dated 18/1/2023, passed by the division bench of this court in WA 357 of 2022. Next, move it as it may, list on so and so.
With this 175 was the part of appeal which we preferred.
Okay.
Against the order.
Okay.
That was a part of the entire.
Okay.
Deeply.
18.
Lord, it is a transfer matter, my lord. My lord, transfer matter. My lord, petitioner, my lord, now at my posting in my lord of frontier headquarters, Tezpur, man. And my lord, he was transferred, my lord, 12/4/2024 to my lord 72 battalion, my lord. My lord, who was situated at my lord, 7 Yoksum, my lord, Sikkim, my lord. My lord, after issuing my lord the transfer order, petitioner serial number, my lord, kindly see my lord page 44. Petitioner serial number is my lord
What is the
257.
ground of challenging?
Page 45.
What is the ground of challenging the?
My lord, what happened, my lord, petitioner's wife, my lord. She's a mentally, my lord, not my lord, well, my lord. So, my lord, she is under treatment, my lord, at the LGB, my lord, mental hospital, my lord, at Tezpur. My lord, the disabled certificate, my lord, page annex 3, my lord, page 32, my lord, kindly see. And my lord, he have, my lord, 2 minor children, my lord. One is my lord.
Is the medical certificate?
Yes, my lord. With the page 32, my lord.
32.
Treatment certificate, my lord, from my lord, the LGB Regional Institute of Mental Health. My lord, after issuing transfer order, my lord, he filed a representation, my lord. He submitted representation, my lord, and my lord, stated, my lord, 5 choice of place of posting, my lord. My lord is willing to, my lord, to go, my lord, at yes, this, my lord, posting place.
But you know, there is a conduct of yours which makes this treatment disbelievable. I may not say, I may not say you may dislike that.
Since 2020.
Line number 8 of your synopsis. Line number 8 of your synopsis. Synopsis, line number 8. That is your conduct which makes it disbelievable that your wife is suffering from mental illness.
Yes, lord. Mental illness. Well, also, my lord, in representation, also, my lord, he stated.
No, but you tell us, if you know that your wife, you see, you are showing us a document that your wife, which was the page?
Page number
Page,
32.
Page 32. my lord.
32.
And representation also, my lord. Page
No, that's okay.
lordship. He did, my lord, finish it.
32. She's in treatment from 2022 to
22.
2024. So this line number 6 happened after she was diagnosed to be mentally ill.
Lordship. In fact, prior to that, 22, she is under treatment in LGBI, but as per the petition, she is suffering from prior to that, but he is not sure whether she is in mental illness
No,
or
but
but
after
yes,
22, how could you have done that? Line number 6.
line number 8.
8. That means for all other purposes, she is not mentally ill.
My lord, he is constant, my lord, because my lord, he is a caregiver, my lord, the husband is my lord, and two minor son, my lord. Child, my lord, one is, my lord, 1 year old, my lord, only. And even, my lord, their
Okay,
transfer
Mishra,
guideline,
this-
my lord, also, my lord, he is
Lordship.
But this has to be stated then if he is
But Lordship,
caregiver.
I have to, if Lordship permits me, although it's a motion stage, I want to some point, Lordship. First of all, that day also one such matter happened, Lordship, but that time it was not with me that this Right to Disability Act is not applicable to the constable GD's, Lordship, because that is a, for others it is applicable, but for GD, this one is there, Lordship.
No, but you still have that policy.
Yeah. But this is for rotational transfer. For annual transfer, whether it is applicable or not.
But their own transfer guideline, my lord, page 106, my lord, kindly see, my lord, clause 17, my lord. That is 4th March 2022, my lord.
For annual transfer, whether it is applicable, it is 106.
106.
106, it is for seeking exemption from routine transfer and rotational transfer. And now he is under annual transfer policy. Under annual transfer policy, Lordship.
That is why, my lord, there is a, my lord, circular, my lord. As per circular, my lord, he, no, my lord, he is in force, my lord. That is why, my lord, he choice of place of posting, my lord, at a 5 location, my lord. That is page 59, my lord, kindly see, my lord. Is an representation, my lord. He is not willing to continue, my lord, at present class of posting, my lord. He is also, my lord, ready, my lord. But, my lord, at least, my lord, his caregiver, my lord, his family, my lord, especially, my lord, his wife.
Where is your representation?
Yes, my lord, page 59, my lord, kindly see, my lord, Annex 7.
50.
59, my lord.
It was in uniform forces. If we try to say what, where, who should be posted where, it will be very difficult. Page number
Page 59, my lord.
59.
Whereas in the annual transfer, I have applied on compassionate ground for my wife treatment without TTA and joining time for the following units, that is 68 Battalion, 1st Battalion, 23rd Battalion, 37 Battalion, and 30 Battalion. So he is, my lord, no, he is, my lord, that he is service in force, my lord. And this is, my lord, as per the annual transfer, my lord. I have annex, my lord, annex are 5, my lord. Circular of the annual transfer. And a application form also online form, my lord. That is also, my lord, he mentioned, my lord. That is annex are 6, my lord. Page 55 and 57, my lord.
Here, Lordship, as per this annual transfer policy, Lordship may kindly come to page 48, Lordship.
Just a moment.
Lordship.
Disability Act, my lord, who, my lord, is clearly stated, my lord, who is caregiver, my lord. Kindly section 2D, my lord, page 66, my lord, kindly see, my lord. Disability Act 2016, my lord. And there is a my lord office memorandum also, my lord. That is 8 October 2018, my lord. I have annexed the my lord office memorandum, my lord. That is Annexer 10, my lord. Page 100, my lord. Sorry, my lord. Page. Page 63, my lord.
Where are your medical documents? This page 30,
Page 32 onwards, my lord. 32.
32 onwards.
32 onwards.
Those are only prescriptions.
Where is the, where is the,
Psychiatry, my lord.
where is the certificate of your illness from a doctor?
My lord.
Where is a certificate from your doctor showing the nature of illness you are
Nothing,
suffering?
Yes, my lord. Note, my lord, kindly see, my lord. This certificate acknowledges only that the above named agent has been under treatment at this hospital without opining the nature, type, duration, severity. Clarification, if any, may be sought from the hospital.
No, you see, the reason is, Mr. Dingia, out of the medicines you are taking, one is a antidepressant and one is a medicine which is normally prescribed for migraine. One is an antidepressant, one is a tablet for migraine. It relaxes brain, no doubt. It relaxes the brain, but it is essentially for migraine. It relaxes. You will see, when I don't read law, I read medical. That is my difficulty.
Even paracetamol also.
No, that's okay. Paracetamol is something else, but since I'm now forgetful, I'm just consulting the net for it. Know the medicines. Because unless you are certified for an illness which comes within the Disabilities Act, you will not be even if you are a caregiver,
doesn't entitle you to protection from transfer.
Mental illness also, my lord, is coming.
No, mental illness, I don't find any doctor certifying mental illness, because if there's a mental illness under the Disabilities Act, there must be a finding to that effect. Those certifications are made by the doctor. That certificate is not available.
Lordship, may, my lord, the respondent, my lord, constituted, my lord, the board, my lord, to whether, my lord, says, my lord, that's some problem or not.
No, that is different aspect altogether. But the question is that the certifying doctor, if the doctor is not yet certified, what would they examine? Because you see, the court on its own motion cannot say that please examine somebody for a mental illness. That would be incorrect under the Rights of Persons with Disabilities Act. The court cannot do it. Because the court must arrive at a satisfaction before ordering an examination, because a healthy person, well, let us say we take a very absurd examples. I am good at giving absurd examples. I am giving one. You see, I pass an adverse order against the if for one writ petitioner against a counsel. He goes outside in the corridor and says that the judge is out of his mind. Correct. Let us say that somebody who is superior to me hears it. Can he send me for an evaluation for my mental, whether I am mentally ill or not? Just because somebody forms an opinion that X may be mentally ill, can I subject him to an examination?
My lord, he also, my lord, stated in his
So
representation.
that's okay, but you have to first satisfy that the wife is suffering from a mental illness so as to enable you to be bracketed as a caregiver. There is a schedule under the Act. So under the schedule, you must fall within that, the illness must fall within that. And unless there is a certificate issued by a competent authority, the court cannot take cognizance of a mental illness. You see, this scheme addresses at 2 o'clock. Because otherwise we have to.
Notice may be issued, my lord.
No, because if it is not, if it's not an illness which is under the Disabilities Act, we have to dismiss your petition. That's why I'm saying. At 2 o'clock, we be prepared. You have to show us something from where we can arrive at a conclusion that he is a caregiver.
Apart from his wife, my lord, he's a 2 minor son, my lord.
No, that's okay.
My lord, 1 year daughter only.
No, that is okay. But you see, we are now dealing with the Act. So under the Act, there has to be a certification before the court arrives at a conclusion that he is suffering from an illness which falls within the schedule of the Disabilities Act. If not, we can't interfere with that order of transfer that lead to dismissal of the writ petition. Come at 2 o'clock, be prepared. You can show us anything.
All right.
Item 19.
Lordship, in this matter, Mr. KB Pathak will appear. He's on legs in another court. That will be passed over for time.
Item 20.
19 for the time being.
Facts of the case. The Lordship would find a description by this honorable court itself on page 187. My lord, what had happened is there was a selection process. Grievances were raised that the marking system given to the candidates based on the same sort of certificates on the same qualification had differed for every candidate without rhyme or reason. Lordship would have page 187, my lord. Para 2. 187. I think just bring everything in a nutshell, madam. May I read? Page 157, para 2. Only 2 paragraphs. effects projected bereft of details are that the petitioners were initially appointed as home guards and therefore thereafter as special police officers by the following the due process of law. However, the tenure as special police officers was for a particular period and their services were discontinued. To give such persons who were earlier SPs an opportunity of public employment commensurate with their experience, a recruitment process was initiated by an advertisement dated so and so by the state level police recruitment board, Assam, for appointment as constable in the AIS. Petitioners claim to have participated in the state recruitment process consisting of physical efficiency as written examination and viva voce in the respective battalions in the concerned districts. In the said written test, petitioners have claimed to have fared well. However, when the select list was published, their names did not figure in the state select list. Contention of the petitioners are that due marks have not been given for the period of service rendered by them either as home guards or SPs. It is also contended that the marks allotted are not of uniform in nature and had differed from district to district, as a result of which the petitioners are left out. Now, here, it was a difference from district to district. In our case, it is between the petitioners themselves in the same district. If Lordship would kindly have a tabular form I have given at page 13. Lordship finds. But here the different at para 7, the different certificates by each of the petitioners given. Lordship will find.
But you are challenging at 2017.
That matter was, in fact, those results had come up in the year 2021. And the litigation continued up to 2023. And the order just which I have read out, at page 187.
So that is 2024. That means you are fence. What do you call fence sitter?
Exactly, it would not be fence sitter because we had to find out those people. Or it was only after much consultation we came to know that the same certificate within ourselves had varying marks. If Lordship will kindly have that page 14 for a moment, madam. Page 14, my lord. Lordship will see the top person, there was a certificate, 0 marks were granted. Down below, Lordship will find at serial number 15, with the same certificate, someone has been given 10 marks.
Which page?
Page 14, my lord, I was referring to. The third last column, my lord, tabular form. Lordship will find at the top it is yes and 0. This was for the ammunition challan, madam. For the first person, Lordship will find yes, the certificate was there, he was awarded 0 marks. Second person has been awarded 2 marks on the same certificate. If Lordship comes down below, serial number 15, he has been given 10 marks on the same certificate. Now, this was referred back to the department by the order which I just read out, where Lordship will find it page 189.
This 0 to 6, these are marks.
These are marks, my lord.
Okay.
Yes says, my lord, that whether I had produced a certificate, and the marks are given just nearby that, my lord.
You are showing us at page 14, serial number?
Serial number, my lord, the top person, the certificate, yes, and the marks given is 0. Immediately below him, my lord, on the same certificate, it is yes, and the marks allotted were 2. Then Lordship would come to serial number 15. Same certificate, he gets 10 marks. Then on the next page, his Lordship would find other discrepancies. The second table, my lord, serial number 3. Lordship will find where the total marks should have been 46, he has been awarded 44 marks. Thereafter, Lordship would find on the next page, page number 16, serial number 16, where the total marks should have been 31.50. They show it to be 29.50. So my total comes down by 2 points. Now, with these 2 points and the correct mark given on the same certificate, I would have been, my lord, in the select list. And that is what this honorable court has directed on the 10th of May this year, my lord. About 1 month back, that all the matters will be remanded back to the department. If Lordship would have page 189. Rather, page 188, madam. Para 5.
Okay, we'll issue a notice then. You respond to it, then we pass orders.
Since the verification process is already being undertaken by them for all the other writ petitions, it is still underway. 2 months' time was given. Perhaps a short notice whether this can be taken up along with those writ petitions for the, not with.
No, those are
petition.
disposed of. Those are disposed of.
Therefore, my lord, perhaps if early disposal, these matters could be considered with them also.
Within 2 months.
My lord. So
That
that was
means-
10-5, 10-7 is. They would not be able to complete it within 2 months. That is there because all the records would have been needed to be called for each of the petitions.
So, not today.
Or lordship may put it as not as a bar for them to take up our cases also along with those. Pendings. Then also shall not be, if they come up with a calculation.
Yes, Mr. Goswami, issuing notice then. But Mr. Mazumdar and counsel for the petitioners, as well as Mr. J.K. Goswami and the government advocate, appearing for respondent numbers.
All the
respondents.
All the
So far, all the respondents. Projecting that the case of the petitioner is similar to the facts referred to in the order dated 10/5/2024 passed by this court in WPC 3734 of 2022 and other connected cases. The present petition has been filed under Article 226 of the Constitution of India. You should notice a motion written over on so and so. We make it in 15th of July then. 15th July 2024. Requisite extra copies of the petition will be served on the honored government advocate in course of the within 2 days. Next paragraph. The tendency of this petition shall not be a bar for the respondent authorities to undertake the exercise as directed by the herein before referred order dated 10/5/2024 passed in WPC P734 of 2022 and other connected cases. To stop the next part to facilitate the same, the petition is permitted to serve a. In fact, I can't do that. It will want to allowing the writ petition.
Yes.
No.
They can take a call whether it can be considered along with them.
Okay. The pendency of the writ petition shall not be a bar for the respondent authorities to take a call as to whether the exercise as directed by order dated 10/5/2024 passed in WPC 3734 of 2022 and other connected cases shall be applied for the petitioner. List on 15/7/2024. Yes, next item.
Wait, please, your lordship. Well, this is regarding transfer. My lord, I'm challenging the transfer order, my transfer order, my lord.
on the ground of arbitrary and my lord nullified. Your lordship kindly see page 20 is my earlier transfer order dated my lord 21/7/2023. Just 11 months ago, my lord, I was transferred from Golaghat to Lakhipur.
Just a minute. 21.
21/7/2023.
Okay, where is that order?
From Golaghat to Lakhipur. That's right. Page, an extra one, page 20, my lord.
Page
Page 20, my lord.
20.
Page 20, my lord. That is the
Your
transfer
serial
order.
number?
Your lordship kindly see, page number 21, my lord, my number is serial number 25, my lord.
25. Okay.
25. So, Kamrup Metro is my home district and Golaghat Sador to Lakhipur. That was my first transfer order, my lord. So then, my lord, I joined, my lord, in Lakhipur, my lord. And now, my lord, present transfer order, that is annexure 3 at page 30, my lord. That is dated 7/6/2024.
Where is that?
Page 30, my lord. Page 30, my lord. Order is 7/6/2024. In the interest of public service, has your lordship got it? Page 30.
Yes. Yes, Lakhipur to
Lakhipur to my lord, Silchar.
you're getting a better place.
My lord.
You're
No,
getting
my
a
lord,
better place.
place is not the question. Question is, my lord, is stigma on my lord, on me, because I am inquiring, my lord, 7 inquiry, my lord. Yes, my lord, this officer is a, my lord, very honest officer. He is doing very good work, my lord. He has detected various anomalies, my lord. Now, my lord, I cannot comply with the order of the MLA, my lord. That's why I am being transferred without even, my lord, complying the mandatory provision that there, if you didn't within the tenor of the transfer period of my lord, tenor completing 2 years, my lord, it has to be, my lord, taking the permission from the chief, my lord, chief minister. That is not there, my lord. And here also, my lord, deputy commissioner transferred me, my lord. There is a power within the district deputy
No,
commissioner.
it says there's a approval of the honorable guardian minister.
Guardian minister, that is, my lord, for your lordship kindly see that circular, my lord.
Where is that?
That circular, my lord, that is page 34. Page 34. Guardian minister, my lord, that is no new circular. That, my lord, if you within the district, otherwise this is not my lord, my appointing authority. Deputy commissioner has a power to transfer within the district when experiences arise, administrative experience. Suppose there is a flood, as the officer has to be immediately put, my lord, then he can, with the permission of the concerned district minister, my lord. But earlier transfer policies still remain, my lord. If within 2 years, my lord, that has to be, my lord, chief minister approval is required. So what they have recorded, my lord? If it is your lordship kindly page 34, my lord, that is a circular.
Yes, I'm there.
In pursuance to the approval of the honorable cabinet and the convey the its meeting held on so and so, the government is hereby pleased to empower the district commissioner with a power to transfer and posted a gazetted and non-gazetted officer posted in any department of the party, any department, my lord. Your lordship kindly see. Particular district, his or her jurisdiction as per demand of administrative expediency, not exigency, my lord, expediency. So, my lord, what expediency is arise, my lord? Here in this case, my lord. So within that district, he has been transferred, my lord. Although he has no power to, my lord, transfer me, but since it is within district, he has a power by this code, this, my lord. Now, your lordship kindly see the next page, my lord, page 36, my lord. Page 36, my lord.
Yes.
That is the office memorandum regarding transfer, my lord. So if within 1 or 2 years, my lord, earlier it was 3 years, normal tenure is 3 years, now it is 2 years. Within 2 years, the chief minister approval is required. But here, my lord, since deputy commissioner do it, my lord, within the district, what, my lord, expediency? Your lordship kindly see, I clearly mentioned what are the inquiry I am doing, my lord. I have not obeyed, my lord, during the period of, my lord, election, my lord, election code of conduct is going on. The MLA recommended some of the, my lord, ration card holder to give them ration card, my lord. But I have not obeyed it, my lord. Since, my lord, code of conduct, that is the main reason, my lord.
Yes, Mr. Bhattacharya.
Lordship, admittedly, as per the circular lordship, when, because this subdivision is also directly under the control of the district commissioner Kachar lordship. And lordship, as per the notification issued by the governor lordship, this is their lordship. That any officer can be transferred lordship and before his tenure, and there should be with the prior approval of the guardian minister of the district. So if your lordship may kindly peruse the order that has been issued lordship, here it is stated, it is mentioned that this has approval lordship. So transfer is definitely for the administrative executive, whether it is written or not written lordship, it doesn't demands that it has to be mentioned their lordship. And that apart lordship, if your lordship once I may place the instruction lordship. Because the chief minister approval is not required when it is within the district lordship, because this subdivision is also directly under the district commissioner lordship. So merely not writing the specific word lordship, it doesn't in any way make any malafide or anything lordship. And if they are alleging anything malafide lordship, they have not, they are stating these things lordship, but they have not made any private respondent as party lordship, who has, under whose instigation this has been done lordship.
Okay.
So my humble submission is that lordship, this will be, this is a valid transfer order lordship.
Mr. T. J. Mahathir and his senior counsel, assisted by Mr. I. Alam and counsel for the petitioner. Also heard Mrs. M. Bhattacharya and additional senior government advocate appearing for the respondents, number 1 to 4.
Yes, 1 to 4 lordship.
The case of the petitioner is that he was transferred by an order dated 21/7/2023 from Golaghat to Lakhipur, Lakhipur, in the district of Kachar. And within a year, by an order dated 7/6/2024, the petitioner has been transferred from Lakhipur in Silchar within the district of Kachar. The Donate Senior Counsel for the petitioner submitted that the said transfer is in violation of the OM dated 6/8/2013, which envisages the transfer orders to be issued after approval of the chief minister. So it is submitted that the transfer order does not contain any reasons, and therefore the said transfer cannot be said to be
without recording administrative expedience, because he has a power.
in accordance
Administrative
said to have been done in accordance with the notification dated 28/11/2023. Which envisages transfer of persons posted in any department within a particular district as per the demands of administrative
expediency.
AEXPEDIENCY. Next one. Opposing the prayer for interim relief, the learned additional senior government advocate has submitted that
even if the word inverted commas, administrative expediency, bracket inverted comma closed, is not mentioned in the impugn transfer order dated 7/6/2024. But as the said order has been passed with the approval of the guardian minister of the district, comma, the said transfer is well within the powers conferred by notification dated 28/11/2023. Next provision notice including notice on the prayer for interim relief, returnable on when so. Make it 19/7/2024. Mr. Mohanto,
My lord. No, let them
there
produce
there
the
are,
record of-
there are judgments of the Supreme Court as well as of this court that once you are suffering order of transfer, you must join first and then.
Yes.
No, your lordship kindly, that's true, my lord, but your lordship kindly see, my lord, let them produce the record, my lord, what administrative actions have they recorded or not, my lord, and there must be an order, my lord. That has to be, my lord. That's why, my lord, submit, my lord, till return will that, my lord, I may be protected, my lord.
Lordship,
Recently, my lord, the judgment of our High Court in Division Bench, when there is an interference by the MLA, then, my lord, it has to be, my lord.
Lordship, Honorable Supreme Court has passed in last month. There is a judgment from the Honorable Supreme Court, Lordship, whether the recommendation also, though I am not saying here, Lordship, anything, but the recommendation of the MLA, because they are also treated to be the public servant, Lordship. This is also there.
They are public representative.
Public representative, Lordship, but these, they have, in that particular judgment, Lordship, it was stated.
Then, my lord, your lordship kindly, that the Monday, let them produce the record, my lord, if that is recorded, but it has to be recorded, my lord,
Okay,
because otherwise he is not my controlling authority. My transfer order can be passed by the commissioner, my lord. But within the district, my lord, it is can generally used, my lord, in time of flood and time of, my lord, because any department, your lordship kindly see, he can transport any department within his district. When there is a,
Which paragraph of this judgment?
my lord, in that judgment, my lord, your lordship will 25/26, my lord. '23, '24, '25, and '26, man.
20?
23. '23, '24, and '25, and '26, man.
Please come back.
Man, you report it, please. Report it, please.
Amar High Court,
Amma.
I think to PNC. Party and to please, but it's okay.
I'm Molima. Ono solo. When in the same department, my lord, that the interim order was passed, my lord, to produce the record in other cases, my lord.
Lordship, if this is so, I shall, Lordship.
On Monday, let them produce the record, my lord. If there is a
Monday?
recording with this. In fact, my lord, I have made a statement and my lord, he has not even taken permission from the guardian minister also.
Okay. Issue notice, notice on the prayer for interim relief, returnable on on 18/6/2024. So
To produce the record, my lord.
requisite extra copies of the writ petition is served on the learned additional senior government advocate in course of the day. Stop. The petitioner shall also take steps within 2 days for service of notice on the respondent number 5 by registered post with AD as well as by email.
My lord.
By email, by routing the process to the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph. As notice has been issued in the on the period for interim relief, the learned assistant senior government advocate shall produce a scanned copy of the relevant records of initiation of the process of transfer of the petitioner, along with the file notings to enable the learned additional senior government advocate to produce the records. She is permitted to send a downloaded copy of this order to the to whom? To the concerned responding
Deputy
authorities.
Commissioner, Lordship.
No, not deputy commissioner, will not have it. But this transfer is by the
From here,
secretary.
Lordship, that department. Yes, Lordship. Commissioner
I'm
Secretary.
not saying.
Yes, Lordship.
Competent.
Yes, yes, yes.
Concerned respondent authority.
Yes, Lordship.
Yes, by list on
18.
same day, 18/6/2024.
Lordship.
Till then, my lord.
I'm not doing it anything.
Till then, I am protected, my lord.
Lordship,
Because if I am
because
joining
today's, these things I am not aware, Lordship. So even if any thing is there, whether the incumbent, if anyone is there, he.
In the next return date, no coercive action to be taken against the
Right.
petitioner.
Lordship.
Deep look.
Don't take coercive action.
Yes, Lordship.
I'm not staying it, but don't take coercive action. Continue. I'll be 5 or 10 minutes late.
Lordship.
Item number 2 at 2 p.m.
Lordship, I have received the para-wise comments.
Yes.
As per the para-wise comments, Lordship, he has applied for discharge, Lordship, on his own request on compassionate ground. And accordingly, the Board of Officers considered his case and discharged him from service.
Okay, but is there any scope of
Yes, Lord.
the petitioner being given the invalidated
But my lord,
invalid, what is called invalid pension?
No, Lordship, since he, by his own volition, Lordship, he has taken discharge from service, he is not entitled to any pension. This is his application for discharge. He was not discharged on medical ground. So he is not entitled to for any invalid pension.
Yes, my lord, as per my instruction goes, these papers were already typed, just they came and asked me to sign it.
No, Lordship, it is contrasigned by 2 officers, Lordship.
It might be so, but it was the case as per my instruction. goes.
No. If that was your instruction, you should have challenged this document. Because this says that you have admitted. You see what has transpired behind this document, we don't know.
Yes. And he has also given a willingness certificate after taking all these are here, Lordship.
According to you take instructions, we adjourn the matter.
I'll file the affidavit, Lordship.
Let's not file the affidavit from medical.
Mr. A. Sharma, Learned,
Lordship, I am.
sorry, I, Amit, Learned Counsel for the petitioner. And this is R. Devi, Learned CEC, appearing for the respondents. The petitioner was discharged from service by an order dated 31/12/2023. At the relevant time, the petitioner was working as rifleman within bracket GD under the 35 Battalion, Assam Rifles. And according to this said, order of discharge dated 31/12/2023 is assailed in this writ petition. Filed under Article 26 of the Constitution of India. Next para. The learned CEC has submitted that as per instructions received by her, the petitioner had voluntarily applied for his discharge from service with full knowledge that on such discharge he would not be entitled to any pensionary benefits. And acting upon the said request letter dated 9/3/2022 from the competent authority had accepted the said request, pursuant to which the discharge order was passed on 31/12/2023. After rendering service for 19 years, 0 months, 15 days. With the resignation notice of motion returnable. It will be date after 4 weeks. Returnable on so and so. So requisite extra copies of the petition be served on the CCC in course of the day. Post list and so and so. Before that, you write the instructions produced by the runner CCC is returned.
Deep Lord.
Item 6 at 2 p.m.
Lord, I have informed Mr. B Chaudhary, my lord, but I don't know where he is, my lord. Otherwise, this rule, my lord, the advertisement was not, my lord, yet finalized, my lord. As per the instruction, my lord.
It's not been,
Not yet, not
but
finalized.
issue office, let him also participate.
Yes, that can be noted. Otherwise, may I submit some law points, my lord? The notification the petitioner annexed, my lord. This is applicable to the officers' service rules, my lord.
Which
At
one?
page 131. Page 131, my lord. There's annex one notification. 1-1, my lord. Page 131.
Yes.
These rules shall be called the Assam Panchayat and Rural Development Officer Service Rules. This is not applicable to the petitioner, my lord. And your lordship may have the Assam Panchayat Act, my lord.
Yes.
First, my lord, lordship may kindly come to section 30 of the Assam Panchayat Act 1994. Staff of the Gao Panchayat. Section 30.
Yes.
Yes. There shall be a secretary and other staff as may be prescribed by government in every Gao Panchayat who shall be appointed as provided in section 141 and or deputed by the government from time to time in respect of the provincialized employees, so and so, so and so. Now, lordship may kindly come to 141, my lord. Section 140. Staff Selection Board, 140, my lord. May I read, my lord?
Just a moment.
My lord. 140.
Just one.
My lord.
Date 40.
140, my lord.
Yes.
Yes. 140, may I read, my lord? Staff Selection Board. All the recruitment of grade 3 and grade 4 staff under Zilla Parishad, Anchalik Panchayat and Gao Panchayat shall be conducted by the state level recruitment commission for class 3 and state level recruitment commission for class 4 constituted under the Assam Direct Recruitment Commission for analogous post in class 3 and class 4, my lord. So in the act, my lord, there is no provision for promotional post to the secretary, my lord, from the petitioners they are holding.
Is this 140 amended?
My lord,
Is this 140 amended?
I have the amended,
Just pass it on.
my lord, my lord.
Because I read, I can't follow. Yeah, 2023 amendment, itu লগাই ল'ব লাগিব আজি। এই নাম্বাৰটো নোট কৰি পেজ 141 গেজেট নাম্বাৰ নটিফিকেশ্যন ডাউনলোড কৰি লগাই সেকশন 140 পেজ 141 140 এই ইয়াতে নোট আছে গেজেট নাম্বাৰ
Okay.
So my submission, my lord, is that, my lord, as per the act, my lord, through the recruitment committee, my lord, we have advertised the post, my lord.
Mr. Bhanta, where you are relying on?
My lord.
You are relying on some document.
Yes, my lord, the advertisement was made for direct recruitment, my lord. If those are directly recruited, then our opportunity will be
Promotion.
filled. Yes, ma'am.
Your
That will be
promotion,
filled.
where is the service rules relating to your entitlement to promotion?
Yes, my lord, some tax collector come road mohra has been temporarily given this charge of the secretary.
No, charge is only an ad hoc.
Ad hoc, but the promotion scope should be there, my lord, but it is not there. So if directly the secretaries are appointed, then it will be blocked forever. And no service.
No, you
rules.
see, Mr. Bhanta, then things are different. The court cannot pass a judicial order directing the government to frame a service rule in a particular manner.
Yes.
Correct. And secondly is, if the advertisement is otherwise in accordance with section 140, then we can't stay it. It cannot be set aside or quashed.
In fact,
And
my lord,
therefore,
service
if
rules
you
is there.
can't set aside and quash, you can't also pass an interim order.
Yes, my lord, then notice may be issued.
My lord, one service rule is also there, my lord. Administrative, the Assam Panchayat administrative rules, my lord. In 140, rule 2C3 is also saying same, my lord. The 141 recruitment, my lord. Direct recruitment only. They have to challenge that rule, my lord, and act.
Mr. Mango, you better withdraw it and then make a challenge. Otherwise, we'll have to dismiss your petition.
For clarification, my lord, notice may be issued, let them file affidavit and.
No, because
they are-
this is an order we can't pass. Ultimately, even if we issue a notice of motion
Yes,
and tomorrow it comes, we can't issue a direction to the government
my lord,
to frame a service rule which is favorable to you. That is something we can't do.
a separate, different that may be fixed, my lord.
Okay. List on 19/6/2024 as paid for by Mr. Mahathir and counsel for the Mr. H.K. Mahathir and counsel for the petition. Mr. S. Datta Leonard, standing counsel for the PNRD, is present. Mr. Zoe, it may not be, your presence may not be required. Oh,
Yes,
acha.
appearing for the
You
respondent
are
five.
number 5. Okay, I'm sorry. I'm sorry. I thought you had come at our request. Okay. Besides the PNRD, appears for respondent is 1 to 4.
Yes.
And Mr. V. Chaudhary, then it's standing counsel for the SLRC, appears for respondent number 5. Next one,
19/6.
19/6/2024. I think you should better withdraw it and then challenge that.
Yes, on that day I will decide.
Lordship, my name is reflected in the court.
The registry shall reflect the name of Mr. V. Chaudhary. Yes. SC SLRC by listing the matter next.
Highly obliged.
Item 18 at 2 p.m.
Lordship, I have talked with my client, my lord. Lordship, some time may be given, my lord. In the meantime, my lord, he also.
Okay. How much time?
10 days time.
Okay, 10 days time is a bit difficult. We are making it on 21st of June, because last week,
Lordship.
otherwise it will be last week, we will find it very difficult. Okay. On the prayer made by Mr. Aaron Dhingyal and counsel for the petitioner, based on 21/6/2024. So, Ms. B. Sharma, CC is present.
Obliged.
Forty-four. Yes, Mr. Saikia.
May please, your lordship. My lord, in this case, the petitioner of your lordship has been subjected to frequent transfer, my lord, without any administrative accidents, my lord. Thus will find a transfer order, my lord. I have annexed only 3 transfer orders, my lord. Prior to that, my lord, he has been subjected to various transfers. I have given the details at paragraph 3, my lord. Thus will kindly turn to page 18, my lord. That is order dated 25th of July 2023. I was transferred, my lord. From Kamrup to Sapormuk. Next order, lawsuit will find at page 19. Page 19, my lord. That is 12th February 2024. 12th February 2024. My name is at serial number 25, my lord.
Page number?
Page number 20.
20.
Yes, my lord. My name is at serial number 25, my lord. And the name of the private respondent, my lord, his name is at serial number 28.
What is your name? Jamaluddin Ahmed.
Jamaluddin was transferred from Sapormuk to Dhekiyajuli.
Yes.
And the private respondent, my lord, Deepjyoti Adhikari, he was transferred from Dhekiyajuli circle to Hojai.
Serial number?
Serial number 28.
28.
My lord.
Yes.
This order was passed on, my lord, 12th of February 2024.
Yes.
Next, the impugn order loss will find at page 24. 6/6/2024.
Page number?
Page number 24, my lord.
Yes.
My lord, this is within a period of, my lord, 4 months. This transfer has been issued, the impugn order, my lord. And my name is at, my lord, serial number 37 at page 25, my lord. I have been transferred from Dhekiyajuli to Sodia, Tinsukia. And the private respondent, my lord, his name is at page serial number 36. He has been transferred from Hojai to Dhekiyajuli again. By the order dated 12 February, he was transferred from Dhekiyajuli to Hojai. Again, he has been, my lord, transferred to Dhekiyajuli from Hojai. Only to accommodate the private respondent, my lord, I have been transferred in violation of the existing transfer policy of the government. Transfer policy says that, my lord, normal tenure is 3 years. And if somebody is to be transferred within a period of 2 years, the approval of the chief minister is required. In this case, my lord, no approval is obtained from the chief minister.
Lordship, in this matter also KP Pathak will appear. And item 19 of the daily list, this item and the next item, they are all similar. There was a list of transfer order. So
Ask him to come.
yes, your lord.
After some time. Okay.
Obliged.
Forty-five.
45.
Same.
Same.
Okay. Pending. Pending.
Item 22 with 23.
May I please your lordship?
Just a minute. Yes,
May I pass over the matter for the time being, lordship?
I'll be, okay.
After some time. Much.
Item 24.
May I please, my lordship? My lordship, the petitioner is an assistant commander of CIPF 164 was now posted at Mount Abu as staff.
You see here in the matter. SS Roy was supposed to take submissions.
Notes, kindly pass over the senior is leading another portion.
Okay. For the time being.
Item 22 with 23.
May it please your lordship.
Yes.
This is a writ petition, your lordship, basically challenging the non-payment of the amount to the petitioners for initially for 3 months, then subsequently it was not paid. There are two, your lordship case. One is a writ petition, the other is actually a contempt matter. So this honorable court has, in the contempt matter, if your lordship will see, the honorable court has directed by 2 orders, initially to pay the regular salary, and subsequently again that was again extended by directing the regular salary, but that was not paid, your lordship, till today. Therefore, this contempt was filed, your lordship, and the writ petition, your lordship, was already filed. Then, your lordship, the respondents have filed an IA for vacation of the interim order in the meanwhile, your lordship, and we have also filed the affidavit in the same. Contempt matter, if your lordship will take it for just for a moment, your lordship will see at page
What is the interim order here?
Page 16. First order, there was no interim, but at page 16, your lordship will see. There are 3 orders. Page 16, your lordship will find.
16 of the IA.
No. In the contempt petition.
No. The order for which vacating application is filed.
Vacating application is filed, that is IA, your lordship will find. Page 15. No, 15. No, there are 2 orders, your lordship. Page 12. 12 and 15 in the IA. The first order is of 12. Then, your lordship, at page 15 that was the continuity of the earlier order.
But they are projecting that you are continuously absent from duty.
Yes, that part, that is disputed, your lordship. I filed my affidavit. There was and also, your lordship, 2 things. Let us take the facts, even if it is correct. Let us accept it to be correct. Then what happens, your lordship? Being a employee of your lordship department, I am entitled to a notice, then an inquiry, and after an inquiry, if there's a punishment of stoppage of my salary, I have no objection to it. Because in that case,
No. Supposing
without.
Supposing I don't attend the office tomorrow.
Yes.
For the salary not to be paid for the day I don't attend the office, for that there'll be a DP. I don't know.
No, there has to be a procedure, your lordship, without.
It's always there, because if I don't attend, my absence will be recorded and my pay is cut.
When it is cut, your lordship, there has to be
There are two things also. I am taking it, first, I'm not going into the facts. What they are saying, let us assume to be true. If it is true, there were 6 days and 4 days, 10 days of somewhere into 3 months, there was that this person was not attending office. And therefore they made an inquiry. And after the inquiry, they said that you are not attending office on so and so, so and so, so and so date. So we are not going to pay your salary. Fine. Now, to deduct the salary, there has to be two things, Your Lordship.
It's not a question of deduction of salary. It's a question of
And
non-payment of the salary for period not worked.
Fine. Then what happens to the period subsequent thereto? Let us assume these three month of June, I have not attended for 10 days. Let us assume. From what happens from July? Because here you did not, even after the direction for regular payment of my salary, you have not paid me any salary till today. Why?
No, where is your attendance? Because that's something we don't
Which
find.
attendance, Your Lordship? Earlier attendance.
No. For the period you are not being paid.
For the not being paid part, Your Lordship, that is the case where I have challenged Your Lordship, that I have attended, but somehow or the other it was not. And with regard to one part, that I have given a medical certificate. And they say that the medical certificate is not correct. In the affidavit that I have filed in the IA, Your Lordship will find that. I have annexed the medical certificate for a particular period. If assuming that to be correct, then why the stoppage subsequent to that? If Your Lordship is right, that fine, you have not attended 10 days, we are deducting 10 days salary. What about the subsequent from August till today, about nearly a year, Your Lordship? This was given on page 29 of my affidavit filed in the IA. And they say in the affidavit they have, and in the IA they have stated that this is not correct. Well, how can this be a fake certificate, Your Lordship? They are saying it's a fake certificate. These are issues, Your Lordship, with regard to even if the person is not attending the office, there is a procedure prescribed. You have to do it. Deducting salary just without giving me an opportunity of an inquiry. And now, till today, that is nearly a year, because that was deducted in June. From June to June, Your Lordship, why you are not paying the salary? In between only 1 month, they paid the salary in the month of August.
Where is the record of that you are attending the office? This is something I'm not finding it here.
Which record?
For whatever period you are claiming salary.
In the writ petition, Your Lordship.
Okay.
Writ petition, Your Lordship, I am claiming my salary with effect from May. Initially, when this was filed, it was only for the period from May 2023, May, June, July. Then subsequently, it was not paid thereafter. August, it was paid, and then it was. That, Your Lordship, will also be reflected in the order of this envelope.
Where is that?
The order, Your Lordship, will find in the contempt petition. Just for a moment, Your Lordship. Contempt petition, page 13, Your Lordship will see. Then page 17. Page 17, in the paragraph, it is stated that current salary till August 2023. And after filing of the writ petition in September 2023, the current salary has been stopped. If that be so, the respondent number 2 will continue to release the current salary of the petitioner during the pendency of the proceeding unless any specific orders restraining the respondents are passed by the court. And secondly, Your Lordship, in the affidavit, they have not said that I have not attended the office after that. It was only for that period which they have specifically indicated in their IA. The IA, they have indicated the period to be, I think, 6 days. There are 4, 5 paragraph, I'll just point out. Paragraph 7 of the IA, page 6. They have stated that it came to the light that the petitioner was found consistently absent from his duty on December 21 for 7 days. I have paid the whole salary for December. January 22 for 6 days. I am paid the whole salary for January 6 days in January, and February 22 for 4 days. This also I was paid the salary.
Okay, in this writ petition, who is appearing for that Jorat municipal board?
SCCL is appearing on behalf of Jorhat Development Authority as well. It's the SCCL Lordship.
Okay.
Actually, now he is on Lex in court number 18, Lordship.
You ask him to be here.
Yes, Lordship.
Just wait for some time, let him come. Okay.
Or lordship can do one thing, subject to the convenience. Can the matter be wholly, totally heard and disposed of, your lordship?
No, it can't because of the fact that in the contempt, the service is not complete.
Service complete, why?
There's no ID card. So therefore it's not complete. So therefore contempt is out. So we are mainly now concentrating on these two IA and this
Writ petition.
in the writ petition.
Yeah.
Let him have his say because in the writ petition, no affidavit is filed.
Writ petition, they have not filed. In the IA, we have filed our reply.
It's okay, but we'll have to. Because it will so happen that they may rely on the IA as their affidavit.
Yes.
We can proceed with the matter.
The allegation is for December, January, and February. And the deduction of my salary was done, not deduction, I've been not paid, stopped my salary from September 2023 when I came
No,
before.
because this is interesting for a different reason. If the authorities will have to undertake an exercise of departmental proceeding to
Yes.
not to pay the salary.
Yes, because that is a
Then-
punishment.
No. That's what I'm trying to understand. Then why should I come to court tomorrow? I'm just asking myself a question. If for work not done, I'm still to be paid a salary and my study for the day when I'm absent can't be deducted, can't be, has to be paid. Then the question I'm asking myself, why should I come and attend my duty tomorrow?
But if your lordship do not do that, your lordship will obviously receive a notice that you have been absenting from office. So we'll
That
take
is-
an
that
inquiry
is-
and then we'll
No,
take a action.
that is a departmental proceeding.
And-
People
yes.
may not want to have a departmental proceeding against me.
No, not, that is a different
no.
aspect. I'm just saying any post.
I'm just thinking aloud.
Yes.
Because I'm just thinking as a common man, if in the office,
Yes.
everybody starts thinking like that once I don't attend office, it will only be that, because that will come as a major penalty of the removal if I'm not
No.
attending office.
There,
But for
except caution, your
non-payment
lordship.
non-payment of salary for the period not worked. For that, if a DP is required, there's something,
Yes, it is required, your lordship, because
it's
if
not a
your
pay-
lordship wants, I can produce judgments also if required.
no,
But not,
definitely.
I cannot do it today, but
It's okay, but definitely do it.
let
because-
him come.
Because somebody is not attending the duty to have,
No, that is an allegation, your lordship. Where is it proved?
so on the salary statement, what comes is,
There is
what would come
nothing
is that
so.
the number of days, working days are 31. Office attended 28. So payment is whatever is there for 28 days.
No,
That's
that is
what
not
comes.
true. That cannot be, your lordship.
That's what happened. That's happened. Suppose you take a leave for one day. Or you don't attend office, you're treated as absent. In the salary statement, how does it reflected? No, if you don't take a leave, supposing tomorrow there's some illness, you don't take a leave, you don't take, post facto, you regularize your holiday. Then how is it shown in the salary certificate? It'll be 1 day's less work.
No. I don't think so, your lordship. I think it
be.
is the whole month. There is not like salary is not paid day after day, your lordship.
No,
In the
but
certificate of
calculation-
salary, the days are not.
Certificate of calculation.
I don't think so.
Mr. Nayak, you'll be knowing better. Supposing a person does not attend the office for a day.
Lordship.
I'm just trying to understand the scheme. Doesn't attend the office. Is it a case of pay cut or is it a pay off for the work done? So supposing he has to attend the office for 25 days, he attends 24. So is it wrong for the officer for the DDO to say 24 days and therefore salary paid for 24 days? Taking 1 day absent.
এদিন যদি মাহটোত absent হয় পইচাটো কাটি দিব নে দিব if it is without pay তেতিয়াহে কাটিব
In some cases, lots if he files one leave application, lots.
No, supposing doesn't do.
নাই কৰা
There is a 25 working day. He attends 24. There's no explanation for 1 day. Now, what do you in your finance diagram? What do you say? It is a pay cut or it's a pay for work done?
Under state government, that cannot be done without the rule, lots. But if he is contractual or works or daily wage basis, lots.
So even if without any information, nobody comes to the office, you can do anything.
Yes.
In state government.
State government you
We
can
have to initiate proceeding against.
proceeding is very a must
Unauthorized absent, that is misconduct. Lots. Unauthorized absent.
is a misconduct when have to be by a DP or
Okay, let him come.
Item 24.
May I present my lordship?
Yes.
My lord. May I please my lordship? The petitioner is an assistant commander of CRPF 164 Battalion, now posted at Mount Abu, Rajasthan. When the petitioner was posted in a 53 Battalion CRPF on 1978, a commandant, namely VP Tripathi, came for inspection in the said branch and started shouted at the petitioner using provocative language, such as "You are appointed through quota, be stay like one." As the petitioner is from a civil caste, the commandant clearly indicated that. Though at that time he was not given any specific tasks. When the petitioner explained that it was against law to use caste to revoke him in front of his colleague, and further that he was not under any definite tax or sense charged at the moment, the submission made by the petitioner further annoyed the commander VP Tripathi and ordered a preliminary inquiry against him vice order in 19/7/2008. In 21/7/2008, the petitioner also made a complaint against a certain officer senior to him in rank before the commandant by registered mail on 9/9/2008 to the Inspector General of Police Shillong, but no action was taken. DIG CRPF Guwahati, by this order dated 22/11/2008, appointed Sri Dalip Singh Ambes, commandant of the same unit, as inquiry authority to inquire into the charges framed against the petitioner by VP Tripathi. The inquiry officer conducted the inquiry without any proper and he does not take the statement of Jagan Singh and V Singh, who were present on duty that day. In the meanwhile, a proof came from the government regarding promotion of the petitioner along with others. And the respondent did not give effect to the promotion as he was, and he was not promoted. My lord, when the petitioner prayed for the promotion of to the concerned authority and reply was given to him, at that as disciplinary proceeding was pending against him, he was not eligible for promotion.
Where is the original complaint by the complainant against you? Pursuant to which the inquiry was conducted, where is the text of the original complaint against you?
The original complaint. Annex, page 16, my lord, Annexure A.
Watch.
View of the, may I read, my lord?
No, it's okay. This I read, but I could not understand it. Yes, please proceed.
On 22/5/2009, the inquiry officer submitted his report holding both the charges against the petitioner stood proved. My lord, the report was total bias because the inquiry officer hold a grudge against the petitioner as he complained against him, against the inquiry officer on earlier on 9/9/2008. My lord, the DIG of police CRPF Guwahati,
What is the name of the inquiry officer?
inquiry officer Dalip Singh Ambes.
Dalip Singh Ambe.
Ambes, my lord.
Why do you say that he was biased against you?
My lord, the petitioner complained against that particular officer on 9/10/2008.
9/9/2008. Where is that?
Annexure 18, page 18, Annexure B.
Please come again, which page?
Page 18, my lord.
18. Where is his name in this complaint, page 18?
19, my lord. His name was not here, my lord.
That's what I think.
Against some officers of
Yeah.
the same battalion, my lord.
No, you have
But
named
his,
specifically
my
his
name is
persons.
not-
Persons you have named. Because if
Personal
you,
name is not here, my lord.
because if you, because
Complaint against some-
please come to come to page 7 of your writ petition. There you are giving the name of this Dilip Singh Ambesh. But you don't say that there was a spat between you and him. That is not your pleaded case.
My lord, petitioner made a complaint against certain officers. Senior to him of the same battalion.
Yes, because I did not find his name either there or in the memo appeal, which you have filed, department appeal you have filed.
Lordship, petitioner came against the stoppage of increment of his two increment against the departmental proceeding. Lordship. Against
No,
that,
no,
he has kept.
because she can build up a case by saying that the inquiry officer were biased against him, therefore this punishment.
That can be, but in the complaint, but against the complaint, he made a complaint against another person, Lordship, not the inquiry officer.
No, that's okay. That's what I think, but she made a statement, therefore we are looking into it. It doesn't appear that
That's why
that is your
record-
pleaded case.
records were-
It's not
he-
there in the writ petition, it's not there in your memo appeal. Allegations against the inquiry officer is not there.
Not there.
You have the record of departmental proceeding against him.
Lordship, there was a disobedient, Lordship, kindly come to page 24, Lordship, of the writ petition, the inquiry report, Lordship.
No, the proceeding, how it took place will only be there.
Lordship, which case?
The departmental proceedings itself, this inquiry.
Lordship.
You have a record of that?
Yes.
Please pass it on.
Because the review proceedings, Lordship. And this is the file, Lordship, regarding his complaint, that page 18 complaint. This was the
For the time being, that's not required.
Lordship.
Because the non-entertaining of a complaint is not a
In
grievance in
terms
this
of court's
petition.
order, this file has been called, this record has been called for what happened to his.
Oh, acha. Oh, okay, I'll see that after some time.
Yes.
Because that's not a part of the prayer made.
Lordship, yes.
That's right. who is senior in position, the petitioner or the person against whom complaint was made, that Devendra?
That the complainant, petitioner against whom the complainant, he is the senior person,
Okay, that person is senior.
senior. He disobeyed the order of that person.
Okay. Yes.
My lord, then a DIG of Police CRPF Guwahati passed an order dated 10/8/2009 holding the petitioner guilty and imposed punishment of stoppage of increment of 2 years with cumulative effect. My lord, the petitioner filed an appeal before the IGP of CRPF Shillong against the improper and unjust order which was rejected on 22/4/2010. My lord, after that he was posted in JK region where he filed a repetition. But it was not maintainable, so it was dismissed with a liberty to reinstate. And he approached Central Education Tribunal in Delhi and Delhi High Court after that. But maintainability is the issue, and so it was both are dismissed, and the same has been rejected for the director. And then he filed a revision application against the order on 22/4/2010 before the respondent number 1. The same has been rejected, but a special Director General any zone CRPF Guwahati. So lots of time has been consumed in the above process.
It's okay. We are not raising the question of delay. You have explained that.
My humble prayer is done by the petitioner.
No, but you have to establish that the finding is either based on no evidence or it's a perversity in the appreciation of the evidence. You are merely saying that because you are a member of the scheduled caste, you are discriminated. But it's a departmental proceeding. You'll have to show that you will show how this discrimination happened. Where discrimination means we can understand it only under Article 14. So, or really under the provisions of Article 16, if you can show discrimination. The question here is that the allegations against you is substantially that you rebuked the senior officer, senior to you, and therefore this DP. The cross-examination which you have
Denied.
Done in this proceedings will show that the pattern of questions was not restrained only to the fact of whether you misbehaved with him or not. You also question about the authority and the charge given to you for the for that number 2, post number 2. That is the ground taken. So if the witnesses say in this, when you are cross-examining him, that you were in charge of that, what you call beat number 2 or something, post number 2. They also say that after the officer is in charge number 1, you are the officer of charge number 2. So that has come. It's also come in your cross-examination from the witnesses that the inspection was being carried out and you came late. And thereafter you came inside and started rebuking the senior officer as to what was his authority. Most of these things are coming out from your cross-examination. So witness number 1, you did not cross-examine the witness. So where others are concerned, you did cross-examine. Most of them you did, you cross-examined. Because there's nothing in your cross-examination to any of the witnesses. There were how many witnesses here? I forgot. It's more than 10, I think. Witnesses examined. How many witnesses, Mr. Roy? More than 12 witnesses are there. In none of the witnesses cross-examined. You took the plea that you have been discriminated for your
Nobody
status,
says.
in the caste. That's not there. Not even one question to any of these 12 witnesses. So one of the questions to one of the witnesses that why did the incident happen? The witness replies that you'll have to say it because you started the rebuking. So he gives that statement in the proceedings.
My lord, he was provoked that he's not working, but he was not given any tasks at that time.
No, you see, you are Mrs. Borkotaki.
Yes, ma'am.
Yeah. Mrs. Borkotaki, you see, what happens is that you put a question to a witness, and witness, instead of accepting your contention, says that you were in charge because you were the second one in the unit, and therefore you are the second person in charge, and you were in charge of beat number 2. What is it? Beat number 2. What is that? Charge number 2.
Guard number 2.
Oh, guard number 2. So you were in charge of that, and there's no evidence from your side to show that you are not given a charge. You'll also have to demonstrate that in a battalion, when somebody is given a charge, because it's a day-to-day work, you are given a formal appointment order to hand you over the charge. I'm asking you this because nowadays I'm accustomed to this few things, because in the quarters where I stay, there are 3 guards, and therefore everybody has assigned duty of 8 hours running into 24 hours, and therefore if guard A goes, he puts B into charge. But I have never seen a documentation of the charge being handed over when it's a battalion, because in the house they call it a group. In a group, when there's a change of guard, I did not see any documentation of handing over the charge. Everybody knows this 8-hour duty is of A. We also know that the next duty will be of B, and third duty at the night will be of C. That's something we know. Question of handing over charge is never there. Even in our High Court premises, when there is a change of guard, here also there is timely change of guard. But I've never seen a charge memo being made. It's a routine work to be done. Because if they start doing it in the High Court, there will be not less than 100 guards at a time. It will be 100 documents a day. Three times it is changed over. That means 300 documents a day. Because when you are given the, you have been given the charge memo, there's a statement made that you are ordered. And the cross-examination is on the line that what happens, how are people placed when the senior officer is there? How will the junior officer will be there? So he says that in the charge, in the gate, in the charge, you will be placed behind the senior officer. That's the nature of cross-examination of witnesses. So I don't think how that can be relevant for the purpose of our determination.
he was subjected to frequent transfer. In 1 year, he was transferred thrice from one place to another, my lord.
So for that, you could have, for that, you have a different channel of agitating. You know, when it's a departmental proceedings and pay cut of 2 years is given, perhaps that may not be a good argument. I'll tell you something of an incident which happened when I was in college. I was a student of Commerce College. And there was a traffic policeman who was standing on in the gate, near the gate of the Commerce College. And some VIP was to pass by. I don't remember, those were, Mr. Rossi, when it was 88, 89. 88, 89, we are classmates. So therefore I'm asking him. Now that's 88, 89, 90, those were troubling days with many incidents happening. VIP was crossing by and this police constable was continuously standing, and when the, I think a officer of some rank came into the college premises and was asking someone, because in college if police enters there will be a commotion. So he requested someone and just was sitting there for some time under the shade. In the Commerce College gate, there's a shade near the, we had a teacher's room. He was just sitting there for a moment, and this constable from there was shouting at him. And he's an officer, he's sitting there for 1 day, full day I am standing here. I have not given a rest. And so he was saying some slang to this officer who was taking rest near a tree in the college campus. Then I realized that an overworked person may be agitated because some other is taking a rest. I mean, he's given a duty in a shade. And this man is in the hot summer standing on the gate. So he's shouting at the officer who is just in a shade. It can happen. You have to demonstrate from here that you were so stressed at that point of time that this incident could have happened. Your evidence is not to that effect. I'm just saying story because I'm a storyteller. Because in the evidence, you'll have to lead that you are in such a stressful condition. You see, what happened was that there was a inspection ordered by a senior personnel in your CRPF, and therefore, to enable this inspection, preparations were going on. Correct. So it is at that point of time that this happened.
Yes, madam.
So in a CRPF or in a army, when there's an inspection ordered, a lot of event takes place. Because people have to be spick and span, all dresses have to be washed, ironed, all the campus has to be cleaned up. The post sentries everywhere where the parade will take place, this, what is that area called? The main area, those are all cleaned up. So all these people who are in the CRPF, they are made to work. You have to not only clean that, even outside the campus, the approach areas, because everything will be cleaned up when a senior CRPF officer is coming for an inspection. It's a notified inspection. So unless you show that you were stressed to lead to this incident, we can't reduce the, even if we accept your contention, but still the punishment we can't say that it shocks the conscience of the court to reduce and to substitute the punishment given with our own wisdom. To the bar members, I think this will be the last matter I can take up because I'll be rising. There's a assigned duty after this. I may not be able to take up any other matters. 3:30 I will be rising. Yes, Mr. Roy, but you can.
And there is nothing wrong in this order, Lordship. He was given
why 2 years?
he has given
Then
ample
stop it.
opportunity, Lordship. He has
Why
not,
no? Why 2 years pay reduction?
Lordship, as per misconduct, Lordship. He has disobeyed the orders, Lordship. He disobeyed lordship. That's why.
But why 2 years?
It's cumulative effect, my lord,
Cumulative effect.
going on.
Otherwise, he's a
2 years means two increments.
two increments.
And an increment means 2 years means two increments. Yes. Any strong point you can make. Mrs. Bhagataki, if you can make any strong point.
And it is of the 2016, order is of 2016 lordship.
No, that whatever because
And the application was filed in the year
because
2018.
this is not her fault. We are taking up right now.
No,
It's
lordship,
not her fault.
the limitation point we have taken in earlier also.
The limitation will not be a ground where we'll
Lordship, that
because of the fact that she did approach
lordship,
two high courts.
that is the
And then she approached where?
JK.
No, JK High Court, then Delhi, then you approached
then
one more
CAT,
place.
CAT.
CAT and
CAT.
Delhi
Ah.
High Court also, my lord.
Ah. So therefore, we'll have to consider that. Because going to litigation 4 times is a costly affair. That point may not be with you. But Mrs. Parvati, if you can give us any strong point where the court can tilt against in your favor. Your only strong point is that witness number 2 and 3 said that you spoke politely. That is the only evidence which is there. But the disciplinary authority rejected that by saying that when they were asked about the conversation, they said that they were far away. They did not know the conversation. They were ignorant of the conversation. Only it said that you were in a soft tone. There's a second point which is in your favor that you also filed a complaint. But to that, what has happened is that a complaint against you was lodged on 19/7/2008. And the complaint was accepted and initiated. Your complaint is on 21/7. So this is a 2-day
Another complaint.
think over period which you got. And in these proceedings, you did not lead evidence for sustaining that complaint. I'll show you that. You have a copy of your evidence? Yeah, have a copy of your evidence? No.
No idea.
You see this. You are Devendra Singh.
7 to
I flagged it. Your complaint is 21/7/2008.
Just given verbal order.
No, no, about your complaint, because that's the only defense you are taking. That you also lost the complaint. But to that, when you gave your statement, this could not be established. You see, I have merely flipped it. The evidence which I got from the file, I just flipped it. So I have not read it thoroughly. I have received it right now and I have just now flipped it. While flipping, I don't read it so thoroughly, but I just carry a general impression. I may be horribly wrong when I'm saying it, but that is the general impression I am having when I'm flipping it, that this evidence to the complaint, the genuineness of the correctness of your complaint was not established when you gave your statement. So because there are only two defenses which I personally found. The two defenses of yours is witness number 2 and 3, and the second is this complaint. So if these two things fail, then the order of punishment can't be interfered with. The court cannot substitute its wisdom to the disciplinary punishment which is given by the authorities. Quantum of punishment may not be in our domain unless we find that it was shocking to the conscience of the court. The two increments do not, it hampers your career for promotion,
Cumulative effect, my lord.
but it can't be said to be shocking. With pass orders, if there's nothing more, because I have a duty assigned, I can't wait. I'd have to rise to the members of the bar.
Lordship is retaining the records,
Please, because I just did, I did not go through it.
Item number 31, but the emergency is there. I work it by order. Can it be on 19th, madam?
Let the court master take a call. Just let him take, because just tell him, because I have to rise.
Can it be taken about 14?
I don't know. Let him take a call. Let the court master take a call. CV.
There's a matter.
Your name is Miss A. Borgotagi? Miss A. Borgotagi, Learned Constable Petitioner. And this is Mr. Royal and CEC. So the arguments are concluded, judgment is out.
Record retains.
Just make a note, the departmental records produced by the Lanet is retained.
Right.
Just tell the court master.
There's a small matter, my lord. It was listed.
Tell the court master. I have to rise because there's a official work.
Fix the date.
Director.
There's a duty, I think almost 3 days I'll be